My Lord, I believe this is really where I started off from.
Mr. Chikata, could you finish so I can record what he's actually saying? It doesn't seem to me that he finished.
And also, there was not the necessary preparation, technically, to show what is in the recording. And the case was adjourned to today, so that could be done. Now, I believe you have seen the recording since then.
Yes, my Lord. I have watched the video of the copy of the video that was attached to the statement.
And the recordings do relate to press conferences.
Yes, where I spoke.
Yes. And where you didn't speak, it's still related to press conferences on the 2020 presidential elections.
Yes, my Lord.
Now, my lords, we may wish to have the recording played in open court, because it is our view that the recordings, as your lordships will see, go to the credibility of the witness and the petitioner.
As we have indicated from the beginning, if they are being shown in order to deal with issues of credibility, we don't have any issue with that. Our concern is that it's not an issue of admissibility. And my lords, this was why I needed to clarify your last order, because
the admissibility comes first. It must be admitted before we see the relevance.
In that event, we are objecting to the admissibility. In that event, if the issue of admissibility,
I thought the witness counsel was cross-examining him some few moments ago. And he said he had seen it and he had watched it. Maybe you have other legal objections. You can be recorded as such.
No, the legal objection is that it cannot be admitted through this witness. It is not admissible through this witness.
No, the witness said he did speak to
He says he has seen it, but it can't be admitted in evidence in this court through him.
Okay.
It is not something from his custody. He says he has watched it. It is not from his custody. It is not a recording made by him. There is he cannot authenticate. He cannot authenticate that video.
The witness has not said so. The witness has not said so.
No, my lord, he says he has seen it, but
Seen it.
on the basis of that, we cannot, on the basis of that, we are objecting to that document being produced in evidence through the witness. The proper thing is for them to produce it in evidence if that is what they are seeking to do. That's why it's an exhibit attached to their witness statement. As an attachment to their witness statement, it is entirely open for them to put it in evidence. It is in fact the process that they have initiated, but they cannot tender that video through our witness. They cannot do that, my lords. They cannot do that, and we respectfully object to that evidence by virtue of Section 6 of the Evidence Act. The exhibit in question The exhibit in question is not coming from the custody of this witness. It is according to counsel, it is an exhibit attached to the witness statement that they are seeking to introduce before this court. And they are entitled to introduce it into evidence through their witness when he is called into court. It is a different matter if you try to ask the witness on the opposite side to be the one to tender it. My lords, we cannot have it tendered through that witness. And my lords, I would respectfully also refer to section 136 which indicates, which provides as for of the Evidence Act, 1361 of the Evidence Act, I'm sorry. Where the relevancy of evidence depends upon its authenticity or identity, so that authentication or identification is required as a condition precedent to admission, that requirement is satisfied by evidence or other showing sufficient to support a finding that the matter in question is what its proponent claims. The proponent of that document is the second respondent. And your lordships clearly saw what happened in cross-examination the other time. The witness literally opened the envelope in which that exhibit had been attached to a witness statement at the request of second counsel for the second respondent. That cannot amount to authentication. And my lords, I cannot see what the problem is in my indicating. If your lordships wish the witness to step out whilst we discuss the legal admissibility, of course that can be done. But once there is an issue about admissibility, authentication is also an issue. And therefore, my lords, I cannot see how I'm not allowed to talk about authentication, if that's what your ladyship is suggesting, because you...
Pardon, what have I said?
Well, you suggested that authentication, the witness has said he has...
Mr. Chikata, you're making your arguments. Kindly make your arguments.
Yes, I'm making my arguments in response to what your ladyship indicated. Because what your ladyship indicated was addressed to me, I believe, and addressed to the whole court. And respectfully, my point is that the issue of authentication is a precondition to the admissibility of the evidence. And we object.
Your Lordships, with all due respect, the objection being raised by counsel for the petitioner is misconceived. And it is misconceived for the simple reason that the witness has identified the evidence that we seek to tender through him. It is evidence about what he said in the press conference, and he's admitted before this court early this morning. We are not talking about Friday. We're talking about early this morning. He admitted that he had looked at the videos, and he admits that they cover statements that he had made at press conferences. So that is an identification and authentication of the evidence. Secondly, he's also admitted before this court that the video also covers statements made by the petitioner and other leading members of his party. So my lords, it seems to me that in terms of the condition precedent, that ought to be satisfied by section 136(1). It is more than met. And we therefore pray that the objection be dismissed.
Are you objecting because the document is attached to their witness statement? Is that the ground upon which you are raising your objection?
No, my lords, I'm objecting on the grounds that if that document, which is their evidence, if that document is to be admitted in evidence, it ought to be admitted in evidence through their witness. And secondly, my lords, secondly, as I indicated, that document's authenticity has to be established. What my learned friend just said, with the greatest respect, about the witnessing that he has seen the thing that he was shown on Friday and so on, how is that evidence of authentication? My lords, I believe, the word authentication...
So, Mr. Secretary, assuming this evidence is not a video, just a paper like this, and he's under cross-examination, can't they show him the document?
My lord,
Mr. Secretary, if I may land, can't they show him the document and then ask him to identify the document? And if he so identifies, can't the document be tendered through him?
No, my lord.
Under cross-examination?
No, it can't be tendered through.
Why, Mr. Secretary?
It can be identified,
yes,
and he can be asked questions relating to it, but it cannot be tendered through him.
It can be tendered through him.
My lord, it cannot be tendered through him.
He can. They can. They can't tender it through him.
My lord, with the greatest respect, this is an important issue which we really cannot just gloss over. My lord, and the reason why it's important is that if the witness is not the maker of that video, he cannot authenticate it. The video's authenticity is important as a precondition for its admissibility. And my lords, I have stated clearly that if it's credibility, and I've said that a couple of times this morning, I've said that if it's being shown to him for the purposes of questions related to credibility, we don't have an issue about that. So, my lords, in that situation, it is not about admissibility. With the greatest respect, in that situation...
The issue is authenticity. We haven't even seen it.
Yeah.
How can we judge whether the thing is authentic or not?
Yeah,
he said he has seen it.
Yes.
Authenticity. But we must observe the thing, we must see the thing. Yeah. Then we can pass judgment whether the thing is authentic or not.
But my lord, you can't do that by admitting it into evidence through him and then seeing it. My lords, that's the problem. You cannot
have to see this thing first.
Yeah, but
I don't know what the current difficulty is. We have to see it first. The gentleman, the witness, is the only person who said he had seen it over the weekend, and he's the one in the box. So that line has been, that threshold has been crossed.
My Lord, the threshold has not been crossed because the threshold has not been crossed simply because he's not just being asked to identify the document. My Lord, and that's why in
He didn't ask to do anything yet. It hasn't even been shown to him. So you're anticipating a question that hasn't been asked.
I'm not, my Lord. I'm stating as a ground of objection that this is a document which the witness is not responsible for. It cannot be admitted through him, and its authenticity has not yet been established. It is a different matter if it is just being shown to him for the purposes of questions that will test his credibility, but if it is about admissibility, we are objecting. I don't understand. My Lord, if I may just finally indicate that if it's identified, it is still open to them when their witness comes for them now to tender it. That's how.
That can be, yeah.
My Lord, what I was saying respectfully is that if the witness identifies it as something that he has been shown and is marked ID1, at the point in time where their witness comes in, that ID1 can become evidence. That is my understanding of the that ID1 then becomes admitted as evidence from their side.
Another possibility. That is possible.
My Lord, respectfully, that's the only possibility.
Mr. Chigata, no, that is not. The first principle that I was saying that they could tender it through him. I think we can debate on it, but not here. We don't want to engage in academic exercise. There could be a debate because I think that once he identifies the document and he finds that he has seen it, he's seen his picture in it, he has seen himself in it, they can identify, they can tender it through him.
Respectfully, the reason why that would not work is because, respectfully, documents are in their total context.
In it, he has seen himself in it. They can identify, they can tender it through him.
Respectfully, the reason why that would not work is because, respectfully, documents are in their total context. The fact that he can identify himself in a part of the document cannot account for the context of the document. Because, my Lord, I mean, especially in these days of technology, your lordships are very well aware of the ways in which, fake news, for instance, gets created, in which things get pieced together which may not necessarily have been happening at the same time. My Lord, I need not go into all those details, but the reality is that he is not the maker of that video. And the fact that he hears his voice, he identifies his face in it, does not make it admissible through him. It does not make it authenticated by him. And it's a different matter where he is just identifying it It's marked as such. He is cross-examined to the extent that is required as to credibility. And then when their witness comes in, he is able to transform it from being something identified into something that he puts in evidence. That's my understanding of the law.
Video to be played for him to identify it.
Hello. Can we request that you play the whole video, so that no allegation of lifting anything?
You want a prospective exhibit to be tendered?
Yes.
How can he truncate it at a point in time? Let
Very well. I'm just, you know. My Lord, I was just directing him, that was all.
Gentlemen, we need to just juxtapose the manual with the electronic. This is just like in the manual world.
Very well.
Yes, what we do in the manual world is what we are doing in this electronic.
I understand that,
yes.
My Lord.
Please start the video properly. Start from the beginning.
And the lecture for giving us.
That's the beginning. That's the beginning.
Working majority in Parliament. 140 seats in Parliament, which is a majority. And no attempt should be made to subvert that. I've looked at the results we've collected so far, and I'm excited, I'm happy with the results. And we won in 10 regions out of 16, and the Ghanaian people have expressed confidence in us. We will resist any attempt to subvert the will of the people.
Have won this election by some 6,166,385, and that constitutes 50.15%.
Only to begin by expressing my deepest gratitude to you for your tremendous support, which you expressed overwhelmingly and convincingly at the polls. There's no doubt that Ghanaians from every region of this great nation of ours voted for change. And we did so in both the presidential and parliamentary elections.
He has won 141. That puts us in a clear majority and will be giving President Mahama the needed majority in Parliament to be able to conduct his business as president. What the clear majority
presidential candidate of the National Democratic Congress, who is the president-elect, His Excellency John Dramani Mahama, will address the nation and speak to issues pertaining to the presidential results declared by the Chief Minister of Swanasari election.
Parliamentary majority as we speak. The NDC, the National Democratic Congress, is still holding on to its parliamentary majority, as our General Secretary stated. As we speak, we know that we have won 146.
Ladies and gentlemen, our collation so far indicates that our presidential candidate, President John Dramani Mahama, is ahead, and we are expecting that the Electoral Commission will very soon come out to declare him the next president-elect.
Let me repeat. Let me use this opportunity to ask a matter of urgency and importance. Call on the outgoing president, President William Akufo-Addo, to concede in the interest of our sovereignty, in the interest of the sanctity of our democracy, in the interest of the very people that we claim he wants to fight for. He must concede defeat, and it's very important.
Let me declare presidential results. Apart from chairperson of the Electoral Commission. But the affairs and the Electoral Commission will offer presidential results to three supporting Mexico. If the various polling stations will declare results to all. And the results are actually declared at the polling station. It is the Electoral Commission before declared or now or office here. Okay, can you see any more to figures here? Airport nationally. In the end, I say figures here are taken from Electoral Commission polling stations across the country, which I said. President Mahama, Odiyanimwa, Obininku. Now, the LC. Our parliamentary member no here. And results are taken from Electoral Commission returning officers here. One declare a call for winners already. 141 years. Yes, sir. And you can say for true parliament.
On this note, let me announce to all our supporters that you are free to relate.
me to begin by expressing my deepest gratitude to you for your tremendous support, which you expressed overwhelmingly and convincingly at the polls. There's no doubt that Ghanaians from every region of this great nation of ours voted for change. And we did so in both the presidential and parliamentary elections. I'm a staunch believer in the experiment of democracy, a system of governance that allows the ultimate decision-making power to rest in the hands of you, the good people of Ghana. We the people who, with an eye towards the future we would like for our dear country, elect representatives to go forward and realize their vision. Government serves the choice, direction, and pleasure of the people of this great nation. And I have had the honor and privilege to serve my country in all levels of government. When in 2016, at the end of my first full term as president, I ran for re-election as an incumbent candidate, I respected the will of the people. I conceded, I stepped aside, and I set in motion a peaceful transfer of power because I understood that it was the will of the people. And if we are to progress as a nation, if we are to live up to the inheritance of our history, one for which people paid the ultimate price, the sacred verdict of the people must be respected. It must be protected. It has been my pledge from my time of service as a representative to the good people of Ghana to do exactly that. And that is why I stand before you tonight and willing to accept the fictionalized results of a flawed election. Brothers and sisters, it is important to remember that the government that is in power controls all of the state resources and oversees all of the state's institutions. The line he treads between his loyalty to the power that is held by the people and by his own desire to hold on to power can be a very thin line indeed. We went into the 2020 presidential and parliamentary elections with assurances from the Electoral Commission and the relevant state actors that it will be conducted in an atmosphere free from fear and that it will be fair, transparent, and credible. Unfortunately, that has not been the case. What we witnessed across the country from Monday, 7th December 2020 exposed a deliberate plan to manipulate and predetermine the results of the election in favor of the incumbent candidates, who, as so happened, controls all of the state resources and oversees the state institutions. Despite all of the ruling parties' inducements, use of monetary enticements, and other such schemes on a scale never before seen in the history of this country, the good people of this country understood what was at stake, and it was clear as the results of the votes that were legally cast that the National Democratic Congress won the presidential campaign. No amount of trickery, sleight of hand, or obfuscation will erase that reality. I'm extremely proud of our parliamentary candidates who have earned for themselves the title of giant elephant killers. We went into the parliamentary elections with a deficit of 63 seats. We made up for our 2016 losses and we're now set to become the majority in Parliament. This historic feat after only one term demonstrates the strength of our great party and the strength of the mandate given to us by the good people of Ghana to lead. In respect of the presidential elections, the facts and figures available to us from pink sheets and other evidence that has unfolded across the country indicate that numerous steps have been taken to manipulate the results of the election in favor of the incumbent. This calls into question the credibility of one of our most important institutional pillars of democracy, the Electoral Commission. It is now obvious to many objective minds that the Commission and its chairperson have been used to manipulate results from the various constituencies, and in that process seek to subvert the sovereign will of the Ghanaian people. Brothers and sisters, one matter requires special mention. The use of the military in this election is unprecedented in our history. Armed forces featured heavily as an intimidating measure to reverse election results, and they continue to be used in the same intimidating role to insist on recounts in areas in which the incumbent has lost, while untrusting election officers during these supposed recounts. We will not accept anything short of a declaration of the legitimate result. To an NBC parliamentary majority. My brothers and sisters, recently since the inception of the Fourth Republic, final election results have always been declared within a 72-hour period to allow for thorough and diligent collation. Surprisingly, this Electoral Commission chairperson announced quite suspiciously, and for reasons known to her, a hurried 24-hour deadline, which, as we all know, would not be met. The chairperson of the East, in less than 24 hours after her declaration, has admitted that she made unacceptable errors which go to the heart of the entire electoral process and cast deep doubt on the credibility of the announced outcome. The Electoral Commission of Ghana has never brought its credibility to this historic low at such a crucial moment. And the election will be with us by working on it.
When President John Mahama will be declared as the president-elect of the Republic of Ghana.
We had you earlier on and didn't by the NPP people here. What's the assurance that you have that giving you that you have that you think, okay, you think at this moment they are saying that by the
I'm sure you have monitored the media. Initially, they speculated 31% of the NDC in the Ashanti region. Their own press conferences, they indicated the NDC has only done it to 1% of the total amount votes cast in the Ashanti region. Because they know that anything above 25% is a victory for the NDC. So we are surprised that they are not sticking to their 21% after the announcement have been made. But they have signed, they have appended signature to the about 26% of the Electoral Commission has just announced at the regional level. And like I indicated, let anybody part of the dispute the claims that are made historically in the Ashanti region. Anytime NDC carries about 25% of the total value votes cast, naturally we have made it to the first house. So this is a victory for NDC. You are aware that we are able to add additional seats to our pre-existing seats in the Ashanti region. It is not negotiable, it is established that John Mahama, inshallah, a few hours from now, will be declared as the president-elect for the Republic of Ghana. And they are right, they know quite well. We are all waiting for the declaration to be made.
Thank you very much. And we have...
And the election to be with us, a working majority in Parliament, 140 seats.
Yes, Mr. Kutampa. Mr. Kutampa.
Mr. Nketia.
Yes, my lord.
I believe you admit that the video recording that we've watched show you saying that the petitioner had won the elections.
My lord, I have watched the video, and I've watched it here. I stand by every word, every punctuation, every sentence that relates to me, Johnson Asiedu Nketia. And there is nowhere, unless we are watching different clips, there's nowhere where I indicated definitively that the first respondent has won the elections. What I said was what I put in my answer last Friday, that we have won majority of seats in Parliament, which figure I put at 141 seats, and that we are cruising, the first respondent is cruising for victory. And that is precisely what has shown up in all the various speeches I have made, which have been clipped together.
So let's understand, you admit everything on the video coming from your image on the video.
From my mouth.
Yes.
Those are my pictures.
Very well.
And those are the words that came from my mouth.
I'm putting it to you that in the video you said, and I quote, the NDC has won 141 seats, and that puts us in a clear majority, and will be giving President Mahama the needed majority in Parliament to be able to conduct his business as president.
Yes, ma'am.
Did you say that?
Those are my words.
I'm putting it to you that you thereby imply that President Mahama had won the elections.
I implied that I expected President Mahama to win the elections because every evidence was pointing at President Mahama's victory. And in fact, my lords, if you permit me, in all the 7 parliamentary and presidential elections that have been held in this country before this one, the presidential candidate and the political party which wins and controls parliament ends up winning the presidency.
Please,
so
Mr.
I have...
Mr. Asiedu Nketia, don't lecture us. You answer the questions I put to you. You can't lecture us here. No, it's not lecture. The question. We've answered the question. Don't give us a lecture of what happens in politics in Ghana, please. Now, yes, my lord.
Please, by way of case management, we want to give you 1 day to cross-examine the witness. Yes, you have to manage because it's not more than 1. That is the maximum we can give you.
Very well. Now, Mr. Asiedu Nketia, you see in the video various clips of your deputy, one Otokuno. Is that correct?
Yes, my lord.
In the video, Otokuno says Mahama has won this election by some 6,166,385, and that constitutes 50.15%. Is that not so?
I heard him say so in the video, but my lords, I indicated last Friday that I was present at the press conferences addressed by my good self and the petitioner, and I did indicate clearly that I will not be in a position to testify about whatever any other official of the NDC has said at their various press conferences. That was what I said.
Hello, I'm putting it to you that the press conferences that have been shown are press conferences organized by the NDC as a party.
Yes, my lord. The NDC has 38,000 branches. Each branch can organize a press conference in their own right. And we have regions. Each region can organize press conferences in their own right. And there are at national level, we have various departments. They can all organize press conferences in their own right. And the General Secretary does not have to be present at all such press conferences.
Now, as a General Secretary, these press conferences were organized with your consent and knowledge.
My lord, I am the chief executive of the party. So, in that sense, I take some responsibility about whatever happens in the party. But where a statement is made by a junior officer that contradicts what the chief executive has said, it is the chief executive's word that prevails.
Now, again, you saw Mr. Sami Jamfi stating that introducing the petitioner as president-elect in the video.
Yes, my lord, I saw it in the video.
Then again, your deputy, who works under you, said, "Let me announce to all our supporters that you are free to jubilate. You are free to express your excitement because the NDC is forming the next government of the Republic of Ghana." Is that correct?
That's correct, my lord. My lord, I'm not aware of any restrictions on jubilations of the right of party members to jubilate over election results anyway.
I'm sure this is correct. And then your representative from Ashanti region, Kwamizu, your regional secretary, said that President Mahama will be declared as president-elect of Ghana. Historically, whenever NDC gets more than 25% in Ashanti, they go to the Flagstaff House.
Yes, my lord, I heard it.
So I'm putting it to you, Mr. Asiedu Nketia, that the thrust of all these statements in the various clips is that President Mahama had won the 2020 presidential election. Yes.
My lord, these statements, according to the videos, were made at different times.
I didn't ask you when they were made.
Some of them were made after declaration, some before declaration, and so on. So it is difficult to put all such together and say that at this point, this was what was said.
No, I'm putting it to you that these statements were made before declaration.
My lord, my viewing of the video indicates that some of the statements were made after declaration.
Even better. And so you admit that some of the statements saying that the petitioner had won the elections were made after the declaration. Not so.
From what I have watched here with everybody here, I can see that this is not a video of one event. These are videos picked and pieced together, and some of them relate to a time period before declaration and others relate to a time period after declaration.
Now, it is no secret that interspersed between these press conferences, the NDC, under your direction, had organized several demonstrations in Accra, stating that the petitioner had won the election and warning the first respondent not to subvert the will of the people.
My Lord, the NDC had organized several demonstrations with three main objectives. One,
please, I have not asked you for
the killing of innocent voters at polling stations by security officers, and nothing seemed to be happening. The NDC made that was one of the purposes of the press conference. The other purpose of the press conference.
Please, I have not asked you the purpose, so answer my question. Please, and don't be taking.
Can you restate?
Don't be taking instructions from, lawyers on this side, please.
Please, let's observe.
Please,
Deacon, please.
My Lord, I know what I'm talking about.
We are closer to them than you. We've not witnessed anything. Please.
Yes, please answer my question, and you had your opportunity to write your witness statement. So now you answer the questions. You understand?
Please, I'm asking the question again, and I answer according to my ability and what I consider to be the answer to the question.
I'm saying that interspersed between these press conferences,
yes,
the NDC organized a series of demonstrations, the object of which was to...
Tin is loaded. You see, it is double barrel. Can't you break them?
Organize a number of demonstrations. Is that so?
Yes, we did.
And one of the clear objectives of these demonstrations was that the petitioner had won the elections and the EC should not subvert the will of the people.
My Lord, the objective that relates to the presidential elections was that the results as declared were flawed. And the commission itself had accepted that the results were flawed, and that's why they kept changing the figures.
So you admit that you said that the results were flawed?
Yes.
Who, in your view, won the results? The elections?
My Lord,
who?
We are not interested in winning or losing a flawed election.
Very well.
We want the election, we want to be winners of an election that is credible.
Now, it is also true that notwithstanding all these statements that your party, yourself, and the petitioner had made that the petitioner had won the election, when you eventually filed your petition, there was nothing in the petition about the petition having won the election.
My Lord, I have indicated earlier.
No, please answer my question.
Please, I'm about to answer the question, unless you are not ready to listen to the answer.
I've asked you that when you filed the petition.
Yes, my Lord.
Yes. There was nothing in it to the effect that the petitioner had won the elections.
In the petition, yes.
Now, again, you claimed in one of your statements that elections were won in the polling stations all over the country. So I'm putting it to you that when you made the statement that the petitioner had won the election, it presupposed that you had the police station pink sheets.
My Lord, I indicated that I never said that the petitioner had won elections.
Now, when the petitioner was telling the whole nation that the NDC had won both the parliamentary and presidential elections, on what basis was he making that statement?
Mr. Gutamba, you can address on it. Yes, you can address on it.
Now, I believe that, as you had admitted during cross-examination on Friday, that you had trained agents at all the various polling stations and constituency collation stations and the regional centers. Is that correct?
That's correct, my Lord.
Now, they are all entitled to carbon copies of all the different official election documents of the results.
Yes, my Lord, they are entitled to.
And I presume
that in some cases they were denied.
You know that you have not stated this important factor in your witness statement. You know that as a fact.
My Lord, I'm answering to you a question that has been asked.
Yes, I'm saying that, and I'm following up, that you know that this important allegation, you have not mentioned it in your witness statement.
Yes, I have not mentioned it in my...
And the petitioner also has not mentioned it in his petition.
My Lord, we indicated that that is what ought to be, but as to whether what ought to be was what happened.
That you have attached is your exhibit B, exhibit A is the declaration, exhibit B, the press release, exhibit C, the 11 constituency summary sheets, exhibit D, the summary sheet of Eastern Region, exhibit E, the 275 constituency summary sheets, which you describe as a spreadsheet of the constituency summary sheets released by first respondent on his website.
Yes, my Lord, I indicated that we chose to rely on the first respondents' own figures, thereby judging them by their own Bible.
So it means that you accept the information on those documents of the first respondent.
The information suggests...
No, I've asked you a simple question. You are saying that you accept the information in those documents as the documents of the election.
As per electoral commission, first respondents account.
Do you accept or do you not accept? That's the question you have been asked.
My Lord, if you can ask the question.
It's the same question.
Ask what?
That you accept the information in the documents that you have attached.
My Lord, I've been advised by my lawyers that is the information, however flawed it is.
Please, we are not talking about what. Don't look there, please. We are not talking. we are not talking about what your lawyers advise you on. We are talking about you.
Yes.
So what do you have to say?
My Lord, because we disagree with the data, that's why we are here.
But you are using the same data in support of your claim.
My Lord, the data must be internally consistent, such that the declaration must be seen to be the product of aggregation of the data. And we are entitled, as a participating party, to look at the data available to us, from which the first respondent drew her conclusion. And we are saying that the data they have submitted does not support the conclusions that have been drawn. And that is why we are here.
Now, you see, you have not. Please look at me, please. So that you don't ask me, I should repeat the question again. Look at me. Now, you have not provided any document of your own showing that neither party won the elections.
My Lord,
please, it's
the documents we are working with, the information we are working with, is the result that has been declared by the...
That is okay. I'm saying, as a matter of fact, that you, the General Secretary, who was directing and coordinating the presidential elections, you have not produced a single piece of independent evidence supporting your claim that neither party won the elections. Simple question.
My Lord, I need to understand what independent means so that I can proceed to answer the question. Independent by way of NDC's own collated figures, or what type of independence?
The carbon, you see, as you know, all the documents that the EC was using to, how do you call it, collate the results from the polling station right up to the regional center, you had carbon copies of them, didn't you?
Yes, we do.
And I'm saying that you have not put together your carbon copies to show that indeed nobody won the elections.
Yes, my Lord, because that is not the purpose of our petition.
So you say what is not the purpose?
I'm saying that we did not come to court to come and take over the work of Electoral Commission, but we are entitled, if we see the results are flawed, they are not born out of the data, we are entitled to challenge and to insist that we must have a credible resource and a declaration that is based on the votes that were cast at the polling stations.
That's okay. I'm saying that you have not provided any basis of your own for your call for a runoff.
No, my Lord, we haven't brought that data here. We didn't consider it necessary to our case to bring any such data here.
You see, do you know why you haven't brought any such document? It is because all the documents you have, all the authentic documents on the election that you have, show that the second respondent had won the election, so you can't bring it out.
That is not so, my Lord, because we produce documents that will support the case we bring to this court. And if the case we have brought to this court is not about coming to retabulate figures the way MPP chose to do in 2013, and we do not need to bring those figures here. We are judging the first respondent by her own Bible. So the figures that she claimed were the figures that were generated and the conclusions that were drawn. We are saying that the conclusions are not born out of the figures she herself has presented.
So, Mr. Asiedu Nketia, I'm saying that indeed your claim for a rerun between the second respondent and the petitioner is based on the verbal slip made by the chairperson of the first respondent in mentioning the total votes cast rather than the total valid votes cast as the basis of determining the percentages.
My Lord,
do you understand the question?
Please ask if you think I don't understand it. Can you repeat it?
Yes. I'm saying that your claim for the rerun is based on the simple slip, verbal slip that the chairperson of the first respondent made when he was declaring the results in using the total votes cast rather than the total valid votes to determine the percentages. Is that not correct?
My Lord, we disagree that it's a verbal slip. No, because a verbal slip in reading out figures would have meant that you read one figure instead of the other. But from subsequent corrections that the first respondent sought to bring up, the figure she mentioned and the correction that was made was not related to the figures of the day at all. Because if you have maybe total votes cast in one column and then total valid votes in another column, it is possible that you read total valid votes for total votes cast, but they will be the same thing. So when you come back to allege that it was a verbal slip, we expect that the correction that you made will relate to the figure which you thought you were reading. But the corrections that they claimed were made did not relate, the so-corrected figures did not relate to any figure that was on the face of the declaration in the first place. So it was a new figure also introduced. So it couldn't have been any verbal slip.
You see, Mr. Nketia, you know, as an experienced player in elections in the Fourth Republic, that you determine who wins the presidential elections based on the total number of valid votes cast. Do you know that?
Yes, I do.
And you know also that it is completely impermissible for anyone to use the total number of votes cast as a basis of determining the percentages. You also know that?
Yes, I do.
Now, you also know that if you listen to your exhibit A, that is the press conference declaring who won the elections. If you tabulate the total of all the votes obtained by the 12 candidates, you will get 13,121,111 votes. Is that not correct?
My Lord,
not correct?
that figure was nowhere in any declaration.
No. Listen to the question. I'm saying, if you tabulate the results obtained by each of the 12 candidates and sum them up, you get a total of 30,121,111. Is that not correct?
My Lord,
Is that not correct?
as per the figures released by the Electoral Commission, that is correct.
Okay. Now, you see, therefore, that being the case, you are not permitted to use any other number to calculate the percentages.
My Lord,
No, it's a simple question.
I was not involved in the calculation leading to the declaration.
Asiedu Nketia, please,
Yes.
the cross-examination, you don't trade questions with the lawyer who is cross-examining you. He prefaced I remember when he was coming to this, he said, you are a veteran in elections, and you admitted yes.
Yes.
Who in Ghana doesn't know the role you have played?
Yes,
Yes.
my Lord.
That was why he is trying to cross-examine you. Don't try to, go wayward as if you are engaging him.
Yes, my Lord, we are all learning. So, I'm sure if my friend met me in Parliament, it would be a different story.
So, Mr. Nketia, you admit that it is completely wrong for anybody to use the total votes cast as a basis for determining the percentages of the votes obtained by the different candidates.
Yes.
Yes. And anybody who does that, his position cannot be accepted anywhere in Ghana.
Yes, my Lord.
You see? But that is precisely what the petitioner does in paragraph 16 of his petition. You can check it and read it out to the court. And then the other 16.
Yeah, paragraph 16.
Read it out.
Consequently, if all votes of the Chiman South constituency were added to the petitioner's case, votes, second respondent's votes will remain the same at 6,730,430, now yielding 49.625%, while the votes of petitioner would increase to 6,342,907, now yielding 46.768%.
And you see that in paragraph 15,
I read paragraph 15.
yes,
The Techiman South constituency has a total registered voter population of 128,018, and if added to the total valid votes announced by Mrs. Jane Adukwe-Mensah as cast, i.e. 13,434,574, the resultant figure would now be 13,562,000. 13,592.
You see, I'm putting it to you that the figure 13,434,574 does not represent the total valid votes obtained by the 12 candidates if you do the addition from the announcement, the declaration in your Exhibit A. It doesn't.
Can you come again, please?
I'm saying,
I want to hear the question.
I'm saying that if you do your addition of the votes obtained by each of the candidates as declared by the chairperson of the first respondent, what the sum you get is not 13,434,574. It is not.
Yes.
If you like, we'll give you a calculator. I'm saying that it is not the total valid votes.
My Lord, yes, it's not the total valid votes, but we are not claiming that that was the total valid vote. This is a response to the statement made by the first respondent herself as the basis for the declaration of the results before taking into account Techman's output. So we are again judging her by her own Bible.
I don't have a problem with that. But therefore, you cannot use what you know is factually incorrect and not permitted by the rules governing our election as the valid vote, total valid votes cast. You can't use that. Even if the EC made that mistake, you can't use that as a basis for your claim.
My Lord, as I sit here, I don't know the total valid votes really cast. All the figures are coming from the first respondent, and that first respondent keep changing those figures.
Mr. Nketia, my question is, please answer my question. Your answer being the case that the 30,344,574 is not the total valid votes. That you've admitted that. You can't, I'm putting it to you that you can't use that as a basis, as a denominator for determining the percentages. You come to that, Kweku. Why are you behaving like that? Yes. Answer my question.
Go ahead.
Answer my question.
Come again, my Lord.
I'm saying that you have admitted that the 13,434,574 that the chairperson of the EC announced is in fact not the total valid vote cast, and that if you do the tabulation of the actual numbers, votes obtained by each candidate as declared on 9th December, you find out that it is 30,121,111. Yes, I'm just trying to help you understand. Okay, and therefore, it is impermissible for you to use this 30,343,574, even if it was used by the EC chair, to determine the percentages.
My Lord, both figures are coming from the same source.
I didn't ask you which source. I'm saying it is impermissible for you to use it as the total valid vote cast.
If the first respondent declares it so, it must be so.
So you see, then if the first respondent declares that the second respondent is the winner, it also must be so.
No, my Lord, because that is why we are here. My Lord, If the first respondent declares that these are the figures, we are entitled to rely on those figures. And when we find out that the figures are internally inconsistent, we challenge her conclusions and then we come to a forum like this.
You see?
Or otherwise, I have been a banker. When a check is written,
please,
and there are problems with the check, please, not one signatory can cancel. You bring it back to where the check was written, and all the signatories will cancel and make the corrections. We have stated that we were not part of any attempt.
Now, you see, I'm putting it to you that you use this erroneous figure as a basis for calling for your rerun. That's what I'm putting to you. I'm saying that you use the erroneous figure of 30,434,754 as the basis for calling for a rerun. That's what you use. Whether it was used by the EC or not, that's what you use. Good. Now, so can you answer?
Yeah, come again.
No, you said, what was your answer?
What was the question, sir?
So I'm saying that you cannot use the manifestly erroneous figure or wrong figure of 13,434,574 as the total valid votes cast to determine the percentages of all the 12 candidates, and in particular the second respondent and the petitioner. That's obvious.
That we cannot use an erroneous figure. I want to get the question well before I can give you an answer.
This is the third time I'm asking you.
Yes, please do.
You cannot use that wrong figure as the total valid votes cast as a basis for your claim that there should be a rerun between the second respondent and the petitioner.
My Lord, that is not the only basis for the
No, please answer my question. I didn't ask you what other basis. We'll go step by step.
Yes, my Lord.
Good. Now, you admit that in paragraph 2 of your, you admit that the petitioner has been a member of the NDC since its formation in 1992. Since its formation, the NDC's formation in 1992.
I beg your pardon, we are referring to...
Is that not so?
We are referring to
the petitioner. Okay. You don't know when...
No, I want to, with the permission of my Lord, refer to the paragraph you are quoting.
No.
No quoting.
I'm asking you a general question.
Yeah, he's been a
but if you think you need to, refresh.
Yeah, he's been a member of the NDC.
And naturally, he was the NDC's presidential candidate.
Yes, my Lord.
Now, indeed, in your paragraph 2 of your witness statement, can you read?
Yes.
Your paragraph 2?
Yes.
To the whole world.
I'm the General Secretary of the National Democratic Congress, the political party on whose ticket petitioner contested as candidate for the office of president in the presidential elections held on 7th December 2020. I testify in support of the petitioner's case as contained in this petition. Yeah.
Go on. As General Secretary,
paragraph 2. I've finished reading paragraph 2.
No, I'm putting it to you that as General Secretary of the NDC, you are the coordinator of the general elections, particularly the presidential elections for the NDC.
I'm the coordinator of campaigns for the party,
Yes.
generally. Yeah.
And as coordinator, you coordinate the work of your agents, the agents of the presidential candidates throughout the country, and they report to you in that capacity.
Yes, my lord.
So, it is correct to say that you had full information on what was going on all over the country during the 2020 presidential elections.
My lord, if I may find out which information we are relating to.
I say relevant information as to how the election was run.
Yes, by and large, I have information.
And I believe that on that basis, you provided petitioner with all relevant information on developments you consider significant, particularly the presidential results.
Yes, my lord.
As you received them. Is that not so?
Yes, my lord.
So, I believe the petitioner has trust in you, and that together with the strategic role you play in coordinating the activities of agents of the petitioner during the elections, he selected you to give evidence in support of his case.
Yes, my lord.
Now, you remember that when the President of the Republic in July 2018 appointed the current chairperson of First Respondent, your reaction as General Secretary to the appointment was that you were shocked and disappointed because Second Respondent was a known pro-MPP person. First Respondent was a known pro-MPP person.
The first respondent
is the chairperson, sorry, the chairperson of the First Respondent is a known MPP person and an anti-NDC person. That was your reaction.
Yes, my lord, those were my words.
Indeed, when the first respondent announced that they were going to compile a new voters register, your party, the petitioner, and you in particular, you strongly resisted same, alleging among other grounds that First Respondent and the President were colluding to compile a new register to rig the elections. That's what you said.
Yes, my lord, and we had grounds to say so.
And indeed, the NDC, of which you are General Secretary, went to court to stop the compilation of a new voters register.
Yes, my lord.
And even when the plan for registration was unveiled, you denigrated it, stating that it was calculated to favor the Second Respondent.
Yes, my lord, and events subsequently vindicated that position.
You see, I put it to you that you and your party, including the petitioner, viewed the chairperson of the respondents with jaundiced eyes and had a predetermined position on her alleged lack of neutrality.
My Lord, we viewed her accurately and saw the reflection of her in our eyes, and that was the basis on which we made those statements.
You see? So it is based on this unfounded prejudice that you have against the first chairman or the first respondent that you are doing everything to discredit the elections.
My Lord, I have not said anywhere that the prejudices are unfounded. I'm saying that they were founded on solid facts.
Now, you see, I want you to look at Exhibit 4 attached to the first respondent's witness statement. That's what I said.
Respectfully, I think we're back to the same problem. Is it going to be put as an identified document or what? Because
now, I'm suggesting to you for purposes of identification for the time being that this is the official Form 13B, that is the Declaration of Presidential Election Results National Summary Sheet. Have you seen it?
I haven't seen it.
Look at the first respondent's witness statement and look for Exhibit 4.
my Lord, respectfully, it is for the council to put to him whatever document he wants to put to him. It's not for him to look for a document. I mean, what is this?
For example, first respondent's witness statement is not in evidence. It's not in evidence yet. Yes. Yeah.
My Lord, my first time of seeing this document was where it was filed.
Very well.
We never even, I never cited it anywhere.
Yes.
I have never signed it. The agents at the strong room, don't have their signatures here. And the announcement, the declaration that was made on the 9th did not relate to any of the figures that I'm seeing here.
We'll come to that. You will relax. So you look at the percentage, the total number of valid votes obtained by the second respondent. What is it on this document?
On this document, yes. I can see 13,121,101.
You see, you've also made an error. I said the total
valid votes
obtained by second respondent.
Oh, okay.
You see, you have made a mistake.
Sorry. Yes, everybody is capable of making mistakes, but there are established ways of correcting every mistake in every situation in life.
Please go on. Now read to the court the total number of votes obtained by the second respondent.
This document, the witness can be made to be reading numbers from a document that is not in evidence.
My Lord, my purpose. Yes. So, very well. Very well. So you will see, Mr. Nketia, that each of the votes attributed to each of the 12 candidates on this document is exactly what the chairperson of the first respondent declared on 9th December. That's the significance. It's the same.
The document is not with me.
But that's the problem. You see, you.
Mr. Akotampa, you have to be patient.
Very well.
Both of you can speak at the same time, or you lose.
My Lord, I'm well advised. So I'm saying that in your witness statement, you have attached a video clip of the declaration by the chairperson of the first respondent.
Yes.
Do you want it to be played so that you can refresh your memory?
Yes, my Lord.
Very well.
My Lord, I mean, the videotape is attached to our evidence. at the appropriate time, it can, my Lord, it can be played. But my Lord, we need to understand what is the purpose, because we cannot just go on in this manner. When a document that we have tendered in evidence, they are going to determine when it is going to be played. Is that the procedure?
No. Because you see, there's a problem with this witness statements which has been introduced. Yes, you see, what we normally do, as you've done in this case, is for you to exchange the prospective exhibits. At least they have a fair knowledge of the exhibits which you intend to tender. Equally so, they also have a fair knowledge of the exhibits which you may tender. So that is why probably you attach it, not to take them by surprise. Yes, and they would want the court to have, the witness who had it annexed to the witness statement to identify it. And I think
Yes.
Please. Now, I think that the issue is that counsel for the second respondent is showing the witness another document, their document, and he's saying that some information on this document that he's showing him is the same as the information that you have exhibited.
Yes, but my Lord, respectfully, that document, he has said he saw for the first time.
Yes, but you can still ask him.
Why is material from that document being used as if it is in evidence? It is not in evidence.
He just wants to show you your own exhibit. If I remember correctly, he wants to show you your own exhibit.
He himself has tendered that exhibit. And so, I mean, if he's going to be asked the question about it, the question can proceed. But he's saying that he wants that exhibit to be played at a certain time. And
no, because he said he doesn't remember the contents.
My Lord, he did not say that. He said he was looking for the document. That's what he said.
Okay.
He didn't say he was not.
Okay. So let him find it, and then we proceed.
My Lord, I think that it is preposterous for counsel to say that evidence that he has tendered, I cannot ask the witness to look at that evidence and ask him questions.
not come to that. We are resolving this matter.
No, but my Lord, this objection has no basis. Very well, my Lord. My submission. And he's saying that they have not played it yet, so we cannot, when they have finished their evidence in chief. My Lord, very well.
Mr. Kotanko, could you kindly remind me which exhibit were you referring to?
They are exhibit A.
Mr. Asiedu Nketia says exhibit A.
Yes, my Lord.
All right. Thank you.
To have your witness statement. Yeah, is it not attached to your witness statement? Exhibit A. It's not the petitioner's. Yes. Yes.
You're listening to our coverage of the 2020 election petition. Thank you for joining us. We've been watching, for those of you watching, and of course those listening on Radio on Joy 99.7 FM, lead lawyer for the second respondent, Akoto Ampao, continuing his cross-examination of the petitioner's first witness, Johnson Asiedu Nketia. What is happening now is a document that they want Mr. Asiedu Nketia to cross-check, and then, of course, he'll be asked questions based on that. They've been going back and forth with that for quite a bit now. Kajang Singh's here following the processes as well.
I believe they are now airing a video as part of the cross-examination. This is a video of the EC chair. Let's see if we can cross over and capture what's being said.
At the end of a transparent, fair, orderly, and timely and peaceful presidential election, the total number of valid votes cast was 13,434,574, representing 79% of the total registered voters. Permit me to present the results in the order of appearance on the 2020 presidential ballot. At the end of the polls, Nana Addo Akufo-Addo of the New Patriotic Party obtained 6,730,413 votes, being 51.595% of the total valid votes cast. John Dramani Mahama of the National Democratic Congress obtained 6,214,889 votes, being 47.366% of the total valid votes cast. Christian Kwabena Andrews of the Ghana Union Movement obtained 105,565 votes, being 0.805% of the total valid votes cast. Ira Kabla Greenstreet of the Convention's People's Party obtained 12,250 votes, being 0.093% of the total valid votes cast. Madam Kwabena of the Ghana Freedom Party obtained 5,575 votes, being 0.042% of the total valid votes cast. Henry Herbert Lati of the Great Consolidated Popular Party obtained 3,574, being 0.027% of the total valid votes cast. Hassan Ayariga of the All People's Party obtained 7,140, being 0.054% of the total valid votes cast. Percival Kofi Akanu of the Liberal Party of Ghana obtained 7,690 votes, being 0.059% of the total valid votes cast. David Asiedu Nketia of the People's National Convention obtained 10,887, being 0.083% of the total valid votes cast. Bridget Akosua-Jiboleku of the Progressive People's Party obtained 6,848 votes, being 0.052% of the total valid votes cast. Nana Kunego Rollins of the National Democratic Party obtained 6,612 votes, being 0.050% of the total valid votes cast. Alfred Asiedu Nketia, independent candidate, obtained 9,703 votes, being 0.074% of the total valid votes cast. Distinguished ladies and gentlemen, currently the election results we have declared exclude that of the Techima South constituency, which has a total voter population of 128,018. The said election results are not ready because they are being contested. As such, collation has not been completed. It is important to note, however, that the difference between the total number of votes between the first and second candidates is 515,524 votes. As a result, if we were to add the 128,018 true results to the results of the second candidate, it will not change the outcome of the election. Hence, our declaration of the 2020 presidential results without that of Techima South. Indeed, if you were to add the entire results or to collate all the results from the Techima South constituency and add that to the percentage and the votes of the second candidate, Mr. John Dramani Mahama, he would obtain 47.873% of the total votes cast. And Nana Budanga Akufo-Addo would obtain 50.8% of the total votes cast. It is on that basis that we say that the outcome of the election will not change. Hence, our declaration of the 2020 presidential results without that of Techima South. Distinguished ladies and gentlemen, on the basis of the foregoing election results and by the power vested in me as the chairperson of the Electoral Commission of Ghana and the returning officer of the presidential election, it is my duty and honor to declare Nana Addo Akufo-Addo as president-elect of the Republic of Ghana.
And the election for giving us a working majority in Parliament. One.
So, Mr. Nketia, you can see that the figures that each of the 12 candidates obtained as announced or declared by the chairperson of the first respondent in her press conference of 9th December are exactly the same as the figures on Exhibit 4.
Lord, I repeat my objection that Exhibit 4 is not in evidence. We cannot be making reference to the content of Exhibit 4.
It is not coming from the witness in the witness box.
No, Exhibit 4 is not coming from the witness.
Okay.
Exhibit 4 is not coming from.
Oh, okay, I see you.
Not in evidence, and we cannot have its content just being smuggled in when it is not in evidence.
Yeah.
My Lord.
No, I see your point. I thought it was the exhibit which
But I thought he identified it earlier on.
But he said he was seeing it for the first time when it was put in the answer of the respondent. He said so. He didn't identify it.
Put up, then lay the proper foundation.
Very well. My lords, in any event, I'm putting it to you that the figures obtained by each of the 12 candidates in what is attached to first respondents' witness statement.
Mr. Kutofa, why don't you limit yourself to what the witness has tendered and which has been shown to us?
All right. So, Mr. Nketia,
What is you trying to say?
I'm putting it to you that if you do the maths, which you do soon, of the valid votes cast or obtained by each of the 12 candidates, you get a total of 30,121,111. Yes, very well.
about a month away.
So, can you tell the court what is 6,730,413 as a percentage of 30,121,111? Give him a calculator. Is it on? He said. What is the votes, the total valid votes obtained by the second respondent, namely 6,730,413 413 as a percentage of the total valid votes in the whole election, which is 13,121,111.
That number is still being taken from a document that is not in evidence. That is still what he's doing, and it's not acceptable.
This is exactly Exhibit A. That's what the chairperson announced. That figure was what the chairperson announced.
We had it, 13,430 something. We had it.
All the numbers of valid votes obtained by the 12 candidates adds up to something. That's 3,000,000.
What she stated, and what she stated was that the total number of valid votes cast is 14,434. That's what she stated. We all heard it.
She stated more than that. She also stated figures for each of the candidates. And this question is that if you add that one to come to a certain asking
to do the percentage in relation to
that. My Lord, if we can go, we can listen again and take down all the numbers that she actually pronounced and make sure, but we cannot use a document that is not in evidence.
He has admitted the figure. The witness has admitted the figure. He has admitted the 13.
My Lord, that number is coming from our witness statement indicates. Our witness statement is actually yes, that figure. Yes, that is right, and that's why I'm saying that if he's answering in terms of what we have put in our witness statement, of course that's correct, but he keeps going back to his exhibit, and that's... No, I don't want... I'm not suggesting that. I mean, I have watched it many times, but if your lordships want to watch it again...
No, the figures, you are disputing the figures. In your exhibit...
My lords, I'm saying that in our own petition, we have given this figure, and indeed, that is a matter that will become very clear in time. But in our own petition, we actually had this figure. So that was what the witness was referring to. That's what the witness was referring to. And that he can be cross-examined in relation to it. It's just that we are not talking about an exhibit, something that is not in evidence.
My lords, with all due respect, I'm hearing some very strange submissions this morning. My lords, if I may be heard. My lords, counsel for petitioner is suggesting that we can only question the witness on things that are in their witness statement or the petition. Is that the suggestion?
You're saying that Exhibit 4.
I'm not using Exhibit 4.
So
I'm using what was broadcast a few minutes ago, the numbers.
Exhibit A.
Yes, that's what I'm using. Unless counsel wants to suggest.
It's appreciated. It's appreciated.
No, but my lord, counsel is always interrupting.
It's appreciated. It's appreciated. It's appreciated. Let the witness answer.
I'm saying, Mr. Nketia, that from the video attached to your witness statement as Exhibit A. The total number of valid votes cast in favor of the second respondent is 6,730,413. Is that correct?
Yeah, I would like to take the question again, yeah.
I'm saying that from the declaration in the video clip that we just saw, which really is the basis of all your case, and you should know what is in it. The total number of valid votes that second respondent obtained is 6,730,413. Is that correct?
That's correct, my lord.
Good. Now, the total number of valid votes that the petitioner obtained from the declaration announcing your Exhibit A is 240,889.
That is so, my lord.
And it goes on to the very end in the announcement. I'm also putting it to you that if you do a sum of all these valid votes, yes. So can you tell the court what is 6,730,413 as a percentage of 30,121,111?
My lord, it's 51.29453 ad infinitum, so it can be rounded up to 51.295.
Very good. So 51.295%. Not so?
Yeah.
Now, what about the petitioner? His total valid votes are 6,214,889. 6,214,889. What is this sum as a percentage of 30,121,111?
My lord, it's 47.365569 ad infinitum, so it can be rounded up to 47.366.
So you admit that from the chairperson of first responders declaration on 9th December, second respondent crossed the more than 50% threshold.
From the declaration as announced?
From the figures that we just calculated. these figures which were announced, if you do them as a percentage of the actual valid, total valid votes, these are the percentages you get for the petitioner and second respondent. That's what I'm putting to you.
But we've fought.
This is what raises the difficulty. The previous question was the second respondent crossed the 50%.
Yes.
In recasting, you change the second part. So can you explain the question as well?
Okay. So I'm saying that from the calculation of the percentages of first petitioner and second respondent clearly crossed the more than 50% threshold.
Well, if the figures are correct, yes.
From your home experience.
Now, again, you see that when you calculated the percentage for the second respondent, you came to a figure of 51.2. You see that when you calculated the percentage for the second respondent, you came to a figure of 51.295. Not so. Yes, I'm just emphasizing it for my next question. Now,
yes, my lord.
You notice that when the chair of the EC was orally proclaiming this, she said 51.592, not so. 592, please. That's what she said. That's what she said, not so.
I can't remember what she actually said. I think said 59. I don't know whether
she said.
Can we play that?
Can we play it back?
Looking back.
Okay.
But you use that argument to arrive at your more than 100%. So you know it.
Yes, I want it to be played back.
Hence, our declaration of the 2020 presidential results without that of Techiman South. Indeed, if you were to add the entire results or collect all the results from the Techiman South constituency and add that to the percentage and the votes of the second candidate, Mr. John Dramani Mahama, he would, the Liberal Party of Ghana, obtained 7,690 votes. The total number of
votes cast. Go back. This is not
434,000.
Hello. Okay, please.
Distinguished ladies and gentlemen, the election was conducted in 38,622 polling stations across the country and in 275 constituencies. I'll now turn my attention to the reason why we are here. At the end of a transparent, fair, orderly, and timely and peaceful presidential election, the total number of valid votes cast was 13,434,574, representing 79% of the total registered voters. Permit me to present the results in the order of appearance on the 2020 presidential ballot. At the end of the polls, Nana Addo Akufo-Addo of the New Patriotic Party obtained 6,730,413 votes, being 51.595% of the total valid votes cast. John Drama.
So you can see from the announcement of the percentage that an obvious error was made by the chairperson of the first respondent. Is that not so?
My Lord, your question was for me to admit that the first respondent announced 51%, 592
yes.
instead of 295. But
it's
my Lord, that is wrong. She actually mentioned 51.595, not 295.
So I'm saying that from the actual calculation of the percentage, which you just did before this court, that was an error. You agree?
Yes, the percentage announced was an error.
Yes. But the correct percentage shows that the second respondent had crossed the 50% plus threshold.
Well, if all the figures are to be believed.
Yes, okay. So now, let's look at the press release of 10th December, which you have attached to your witness statement as your Exhibit B. Now, I'm putting it to you that if you add all the valid votes obtained by the 12 presidential candidates, you get a total figure of 30,119,460. But that excludes Techiman South, of course.
My Lord, I want to read with the...
You do the addition.
$30,119,460.
So,
adjourn for about 20 minutes and come back.
Very well, Your Lordship.
Yeah. Okay.
All rise.
Discharging.
In this election petition 2020, we've seen lead lawyer for the second respondent, Asiedu Nketia, continuing his cross-examination. The court is on recess for about 20 minutes, as announced by chairman of the panel. So we've seen Asiedu Nketia continue with answering questions from Asiedu Nketia. But before the cross-examination started, let's take you back a bit to the cautioning of one of the lawyers. But before that, we want to say that the election petition update is brought to you in association with Petrosol Clean Fuel in full quantity. It's always a delightful experience. DBS Roofing, we truly are your roof experts, and COA make sure the immune booster for your general well-being. We'll be taking you through what you may have missed. This, of course, is Joy News, as our coverage of the 2020 election petition. So today, Mr. Asiedu Nketia continued his cross-examination, but before that, I promise to take you through what the court said to one of the lawyers on the side of Mr. Kufuor, and that's Frank Davis, drawing his attention to the fact that the court is not comfortable with his comments. Started with a video recording of the petitioner, John Mahama, the witness, Asiedu Nketia, and other NDC officials. There was an objection raised by Mr. Chikata, Mr. Mahama's lead lawyer, on grounds that the videos had not been authenticated and that the evidence could not be tendered through Mr. Nketia. This was, however, rejected. So the court went on and we all watched and listened to the content of what was played, a series of press conferences and an interview as well. There were questions asked based on that. But we've also heard Mr. Asiedu Nketia make some comments through his cross-examination that they are not interested in being winners of a flawed election. They want to be winners of a credible election. But the whole process, the whole idea of the cross-examination, of course, is to discredit the witness and the petitioner. So really, that's where we've come. We've seen Mr. Asiedu Nketia being handed another calculator. Again, this is the second time that he's put in ardent figures in the courtroom. We'll be touching base with our court correspondent Joseph Akable in a little bit, but due to hard times, we've become value hunters. But are we hunting for value the right way? Remember, your engine is more valuable than just cheap fuel. Be smart, hunt for holistic value. Holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, we serve clean fuel in full quantity at a fair price, and that is holistic value. So come to us, Petrosol, clean fuel in full quantity. Now, after several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experience the amazing touch of ColorLink Plus roofing sheets in 26 years, which means ColorLink Plus roofing sheets always stay clean and beautiful for you. And there's more. We're giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited in Accra on the Spintex Road in the DBS building near Papaya Restaurant. Call their hotlines on 024 084 4444 or 054 328 6637, or visit their factories in Kumasi, Tamale and Takrady. DBS Industries Limited, we truly are your roof experts. This election update is brought to you in association with Petrosol, DBS Roofing and Koa Mixture. Our court correspondent Joseph Akable joins me now on phone so we can go through a few things. Joseph, let's start from the very beginning. Let's talk about Frank Davis and the quashing from the courts. But let me ask about his demeanor. I know because of the mask it's difficult to read the facial expressions of persons these days. But generally, what can you tell us about how he behaved whilst chairperson of this panel was talking to him?
He was very calm. He actually stood upright as the justices of the court through the Chief Justice addressed him. And it's worth putting into context that the concern they raised stems from the Legal Professions Act. That makes the point that when you're a lawyer on record in a case, you cannot grant media interviews commenting on that particular case while it remains pending. And so the point that the court made was to the effect that because he has been announced as counsel in the case, he should be advised that that particular law is still in force. And so the point was also again made that other lawyers who are not parties to the case, you can give such commentary and grant such interviews, but you should not do so in the robe that the lawyers were into the courtroom. And so that was the point that the justice made. But he was calm and he stood up and acknowledged and said he was so advised after the judge had made a particular point. And so it's not too clear as to who will be speaking on behalf of the second respondent going forward, because Mr. Frank Davis is the one who has been handling that, and as it stands now, it will mean that they would have to get a lawyer who is not a lawyer on record perhaps to be speaking on their behalf, and so that remains to be seen. And that's why you realize that there was no reference made to the team of the second, the petitioner. There was no reference in the sense that for the petitioner's side, you have Dr. Dominic who addresses us, who is not a counsel on record. The counsels on record for the petitioner so far is Mr. Asiedu Nketia, Tony Letha and Chachuli Chikata. Those are the two counsels on record, and so that's why no references were made to that particular side.
Talk us through the general atmosphere in the courtroom today. This was supposed to be a continuation of what was started last Friday in terms of the cross-examination. Lead counsel for Mr. Kufuor Akoto-Ampao.
It's quite calm, and for those who are privileged to be in the courtroom, it's that of a varied reaction. So there are instances where you hear people laughing depending on what responses comes in. There are instances where you hear people sighing to say that, what is happening? And there are instances where people are like, okay, this shouldn't be asked. And there are instances where you get a sense that people are reacting in a manner that suggests that they are surprised by a certain response that has come out. But it's been that of paying close attention to the process that has been happening so far, because it's been a bit of a calculation and it's been a certain narrative that is being put across that if you are in a courtroom, you are fortunate to be in a courtroom and you are not paying attention to the narrative in terms of how it's being carried across, you may lose the entire plot. And so it's that of attentiveness, and there are moments of varied reactions, either of excitement, either of surprise, or disagreement with a response or a question in the courtroom, and they mostly come from different quarters. And so you have the petitioner on his side, on the right hand side of the court, while you have that of the first and second respondents. The first respondent is actually in the middle, and you have the second respondent on the other side of it. So that's how it has been so far.
Joseph, there were, of course, you've talked about that NSMQ moment where Asiedu Nketia was given the calculator again this time around. But, it got heated at times, and we've seen that the judges had to come in a lot more times today. either because Mr. Chikata has raised one objective or the other. And so there's been a bit of the judges coming in often today.
Yes, at a point, it sounded actually like Mr. Kotampa was getting a bit upset due to the number of times that he was being interrupted by lawyers for the petitioner. And the judges have come in a number of times, one, because sometimes the same question is asked a number of times, and it relates specifically to the total valid votes, and that question came up a number of times because each time Mr. Chikata came in, the point was being made that the figure that was being referred to was different from what is in the declaration by the Electoral Commission, which has been attached as evidence by Mr. Asiedu Nketia. And so Mr. Kotampa kept laying the foundation by making reference to what figure he's referring to, and that sounded a bit repetitive on some instances. And so the court came in to remind him that that question had been asked and already answered, and each time it followed through with that. And so that is what has accounted for the interjections that we've seen today. But beyond that, too, when there are objections and when there are clarifications that the panel needs to seek from the lawyers, do they come in with those clarifications as well?
And the court has reminded Mr. Kotampa that he has today to do his cross-examination. The time will not be extended.
Yes, the Chief Justice did make that announcement, and the context for that too is that, I mean, we know that this is a hearing that is time-bound in the sense that the court is working and has already indicated that it is complying with CI 99 to ensure an expeditious hearing of the case. And so the court did indicate to him that he has today to finish. It is worth putting into context that aside from Mr. Asiedu Nketia, who is testifying, the other individuals who are to testify or will be cross-examined, as because of the current system of filing a witness statements instead of the past where you have to now lead evidence. And so when Mr. Asiedu Nketia is through and is discharged by the court, we know that the EC chairperson, but even before the EC chairperson will take a turn, there will be Dr. Michael Kwesa-White, who will be the second witness for the petitioner. Then the respondents, the first respondent will call upon the chairperson of the Electoral Commission, Jane Mensah. Then aside from her, in terms of the second respondent, there will be Peter McMenu, who has been given a power of attorney by President Akufo-Addo to testify on his behalf. And so it is because of the time the time that the court is working with, that's why that indication was made as well by the Chief Justice, and he made the point that he should finish that. And so we expect that Mr. Kotampa will finish that today.
And Joseph, we've seen a few people on television, but who is in courts in terms of the three parties?
I spotted Professor Nana Jenopoko Ajiman. He was Mr. Mahama, who is the petitioner in this case. He was his running mate in the 2020 election petition. She came in midway during proceedings, but by way of Mr. Mahama himself, he's not in court once again. And he's been represented by Mr. Asiedu Nketia, who is again in the box testifying on his behalf. There is also Sami Jemfi, who is the National Communications Officer of the National Democratic Congress. The National Chairman of the National Democratic Congress, Samuel Fusampofu, came into the courtroom midway into proceedings as well, so he is also seated in the courtroom. Then there are other members of the NDC who belong to the legal fraternity, like Dr. Dominic Ayine, the former Deputy Attorney General, who sometimes speaks on behalf of Mr. Mohammed's legal team. There is also Edu Jitamaklo, another member of the legal team, is also present in court. Marietta Briapio-Pon is also in court, together with another legal practitioner, Fahad Castle, also present in the courtroom. In terms of that of the side of the respondents, the first respondent, specifically the AC chairperson, Jane Mensah, is in the courtroom. She is actually seated and flanked by her deputies. On her left is Dr. Bosman Asaro, and right is Samuel Tete, as well as the Director of Communication, Sylvia Arno, is also present in the courtroom. By way of the second respondent side of the courtroom, I spotted the NPP chairman, Mr. Freddie Blay, a short while ago. He actually exited the courtroom when the first session ended, and we understand that he's leaving the court premises, and so he's present here. There's also the General Secretary, John Buedu, also present. Henry Nana Boache, who is the National Youth Organizer of the NPP, the governing NPP, is also present in court. The Minister of Justice and Attorney General Designate, Godfrey Yeboah Dame, is also present in the courtroom observing proceedings. And so that is by way of some key individuals that I have cited in the courtroom so far, Mamavi.
All right, Joseph, this is supposed to be a short break, so we'll allow you to take your seat. Maybe grab some snacks and take your seat so we won't miss anything in this proceeding. Joseph Akable is our court correspondent. The court is on recess now. In studio with me is Koji Angsen, who's also been following with this. The processes so far. We started at about 9:30 this morning. It's still Johnson Asiedu Nketia in the witness box, and it is still Mr. Akutu Ampao cross-examining him.
It's been a fascinating study this morning, and it's even better for us because we have something to contrast it against. Yes, last week on Friday, we observed Justin Amenuvo, who represents the first petitioner. The
first respondent?
The first respondent, thank you, the Electoral Commission. We observed him cross-examine the witness, and we observed how that went. I think Mr. Ampao also had the advantage of observing that. So you can tell that he's taken a completely different approach to what we saw Mr. Amenuvo do. Mr. Ampao appears to be extremely methodical. He is intent on keeping the witness to the issue. He is intent on keeping the witness to his questions and nothing more.
The is his lawyer?
The witness.
Okay. Chacha Chikata?
No, the witness.
Asiedu Nketia?
Yes, Mr. Asiedu Nketia. I don't know why his name wasn't coming to me, but he is a skilled orator. He's somebody who, if you allow the space, will convey his message to you by any means necessary. And I think Mr. Ampao observed that from the cross-examination that was done by Mr. Amenuvo. So he is seeking to limit Mr. Asiedu Nketia's ability to use every question as a platform to provide the information he wishes to provide. So he's trying to keep him to the questions he's asking. We are yet to see whether that's going to yield positive results or not, but clearly it has resulted in a very methodical cross-examination where they move step after pedantic step towards some inexorable conclusion that we are all going to hopefully see by the end of this process. It's been fascinating to watch the differences between the two cross-examinations.
In terms of the strategies being used here. So you can join the conversation on social media, particularly on Twitter. Just use the hashtag election petition and let us know how you're following and your thoughts on the processes so far. Our petition update here on Joy News is in association with Petrosol Clean Fuel in full quantity. Is always a delightful experience. DBS Roofing, we truly are your roof experts, and Koa Mixture, the immune booster for your general well-being. Could you let's talk about those, the calculator moments again. I guess the National Science and Maths quiz and the quiz mistress will be trending again today. There's a part 2 of it.
No doubt, no doubt. And you see, for us, lay people observing what's happening in the Supreme Court, all of these things look like novelties, things that are, of interest and in some cases amusing to us. But in reality, these are simply necessary processes, steps in order to certify and ascertain facts. You want your witness to either confirm or deny a fact, and you have to have the fact. Sometimes that fact can only be arrived at using a calculator. So it's amusing to us. It gives us endless memes, but no doubt these are things that are necessary for the processes in the Supreme Court. You can tell the Supreme Court justices have been very quietly and patiently, observing some of these processes, even though the rest of us at home, who are the other panel of judges, as far as this thing is concerned, we have found them endlessly amusing.
Let's try and find out from Samson Ladiayenene, who's thankfully joined us. There were some technical things that played out in court, and we want to get a better understanding. Samson is a lawyer. Very good afternoon to you, Samson Ladiayenene. Thank you so much for your time.
Hi, I'm Abi.
Great. So there was the initial issue of admissibility. Can you explain all those technical objections being raised by Chacha Chikata to us who are not lawyers, but we're interested and we're following?
Okay, so I think the question of admissibility was raised in respect of the video that was going to be presented, correct?
Yes, sir.
Great. So the general principle, as you may have seen, for example, when Anas produced his video on the judicial corruption, and some of the judges were indicted and had to appear before the disciplinary committee, the point of law and practice was that the piecemeal or piece together footages was not going to be admitted, and therefore he needed to present the entire raw footage so that they know what started to what point. And often, naturally, lawyers, when things are being supplied in the courtroom, we will raise objections on some of those grounds. I remember Dr. Ali Gabas, for example, when the trial was going on and Manasseh Azure's recording of him was to be presented and it was being objected to, the intervention we needed to make was to be sure that we had the full detail of it and to be able to identify the custody from which it is coming from. But you see, there's one thing about the process. Once you allow the witness who is in the box to identify the document or thing for the purposes of the cross-examination, and they identify it correctly, you will have a difficult task now saying that it should not be allowed in on the record. So I think if you follow, it may be on the basis that the witness or the particular document or thing had already been identified. Once it's identified, then it goes. So I suppose that is what has gone on. That's the small technicality that I can explain. So while the general principles are there, there are also the exceptions to the general principles. As we were talking about last week, for example, the rule that I referred to as the rule in Abuaba, the traditional, it means that it says that if you kept quiet when the evidence was being introduced, then you will not have the opportunity to object later anymore. So your objection must be timeously done. Once you don't object when it's being presented, you don't come back later and say, oh, forgive me, but I forgot. I should have objected to this, and I am now, no, it will be too late.
And then, Samson, just before you go, help us also understand. So, Asiedu Nketia is testifying, but to what extent? Maybe I should rephrase because I don't want to get you into trouble. What is being picked out of his testimony?
Right. So I can once again help all of us to think about what generally a cross-examination is intended to do. And as you mentioned earlier, before you started this, you spoke about the fact that the purpose was to discredit him. Yes, it's a major part of what we do in court. So your credibility is important to be used to weigh how we should take what you say. So he has presented a witness statement, which is his testimony. And it is that testimony on the back of which the cross-examination is being done. As I explained the last time, we don't do examination in chief anymore because your testimony, which is on oath, is your examination in chief. So this is now the cross-examination. The cross-examination is intended to test or put what you have said and your document through the judicial test. It is after it goes through the judicial test and it survives that you may win a case. So in this case, he clearly has started on the point, on the note. He started on the note of seeking to question or put the credibility of the witness in doubt, that he is not a credible witness, on the basis that he had made statements earlier suggesting something contrary to what he's talking about in court today, with regards to not being able to say straightforward that the petitioner had won and that the petitioner was actually the victor in the election. So he used various statements that unfortunately it appears that, did I say unfortunately? It appears that he was pinned down, and the witness was also very clever. He said, I can only talk about what I said, and as far as what I said was concerned, it was projectional. And then issues about whether when particular statement was made was concerned, whether it was made before or after the declaration and all that. Then the second part, which he now is focusing on, is not that much of seeking to discredit the witness, but now seeking to take the, like they say, gold is what it is because it goes through fire. So it's now testing the evidence of the witness. And so they are doing the math. And he does it and says, this is the number you got, right? That number crosses the Article 53.3 threshold, which is that one must have crossed the 50% mark, must have gotten more than 50% to be electable or to become a president-elect. Then he says, well, that's the first respondent, chairperson's, numbers. Then he's asked questions about them. So you can see that now his focus is not on taking things outside of the courtroom or anything, but staying right there on the number. And that's what leads to giving him the calculator to do. And you can see, like Kojo said, Akoto Power is, if you like, a Methodist. He's being very methodical. So he's not in a hurry to jump anything. And you could find, even in the courtroom, the judges said he was lumping up a number of questions. Ask one, and then proceed after that. If you like, the law, many times, is also a question of logic and psychology put together. So that's what is going on, to seek to prove or disprove the case of the petitioner.
All right, so I'm saying, why aren't they giving him time in terms of limiting him? We know that he's been told that he cannot go beyond today. But Samson, I guess we have to have that conversation maybe later on, because we see that the justices are back to take their seats. So we have to take our viewers and our listeners back to the Supreme Court to continue hearing this case. All right, we will be taking you back to that courtroom pretty shortly. Samson Ladi-Ayenini, very, very grateful for your time. Kojo still here. Your expectations? We're going to be going the whole day, it looks like.
Well, Mr. Ampao has today. He has to make the most of it. He started off by, first of all, seeking to get the witness to, admit that the petitioner, or perhaps the witness themselves, the witness himself, had pretty much declared the petitioner as the winner at some point, whether before or after the declaration. And then there was some back and forth over the exact time some of these press conferences were done, who spoke at them, and so forth. But I believe we have a lot more to go right now as we enter the second leg of this cross-examination.
The total valid vote cast obtained by the second respondent as a percentage, if you calculate the total valid vote cast obtained by the second respondent as a percentage of the overall total valid votes of 13,119,460. What percentage do you get?
The percentage obtained, the percentage I obtained, assuming these figures are all correct, 51. Assuming the tallies are correct,
yes,
then the percentage comes up to 51.302%.
By the way, have you provided any evidence in your witness statement, or is there any pleading in your witness statement which is saying that this figure is wrong? The figure of 6,730,587. Continue your exhibit B.
My Lord, we tendered in regional coalitions for Eastern region to demonstrate the fact that those tallies there, the tallies that were arrived at were not exactly reflecting the votes.
We'll come to that tally in due course. But I'm telling you that even that tally, assuming it is right, will not make a difference as to whether or not certain respondents crossed the 50% threshold. But we'll come to that. So now, from your exhibit B, the petitioner obtained 6,213,182. Not so?
Yes, my Lord.
Now, can you tell the court what that figure is as a percentage of the 13,119,460?
If the tally for the petitioner is correct as stated here, the percentage will come to 47.359.
No, but even if it is not correct, what is it? Because this, you are talking about
47.359%.
So whether correct or not, that is the percentage, not so.
That is the percentage reflected in these figures.
Yes. Now, so I'm putting it to you that here again, second, your petitioner had not crossed the 50% threshold, more than 50% threshold.
According to this data, yes.
Yeah. And now, you notice that these figures on Exhibit B, your Exhibit B, do not contain the Petiman South figures. Not so?
Yes, my Lord.
So what the chairperson of the first respondent said on 9 December was that if you were to add the whole registered voter population of Petiman South to your petitioner's total valid vote, it will still not make a difference as to who had crossed the threshold. Is that not so?
Yes, my Lord.
Is that not correct?
She said so.
But is that calculation not correct? Is that
unless I recalculate.
Okay, so I'll take you through it. So, you are invited to add the total voter population, registered voter population of Techiman South, which is 128,018 to the 13,119,460. Please, I know what I'm doing. I'm prepared for this thing. You add the total voter population, registered voter population of Techiman South, to the total valid votes here, which is 30,119,460.
When you add the total registered population of Techiman South to the 13,109,460.
Yes.
I got the figure 13,247,478. And
what figure did you get?
13,247,478.
Now.
Okay, then let's do it again.
Now, can you tell the court what is the percentage of the second respondent's 6,730,587 of that figure? I think we got it wrong, Bravo.
My Lord, it comes up to 50.806.
Now, if you add the whole of Techiman South votes to the petitioner's valid votes as of that time, tell the court how much it comes to.
Petitioner's valid votes as per these figures.
Yes. That is 6,213,182 plus 128,018.
Months
128,000
128,018.
018.
128018.
Yes.
No, there's some fundamental problem. Thank you. Yeah, Lord, you get 47.867.
Now, do you want to...
Just a moment, let me do another calculation.
It's 47.874%.
No, I'm getting a different figure, 47.867. I don't know what that is.
As you can clearly see that...
Please, my Lord, give me just one moment to... Give me a minute to cross-check something. Yeah.
So it's 47.867%, not so?
Yes.
Good. So you can see that if you add the whole of Techiman South's registered voter population to the petitioner's total valid votes and calculated the percentage, you get 47.867 for the petitioner.
If the figures are correct, yes. But the problem is with the changing figures.
We'll come to
At
that.
every
Don't
point,
worry.
new figures emerge, so you don't know which one you are using.
Don't create problems for your heart. We'll get there. You see? So, now, if you go to the 9th December declaration,
yeah,
and you add the whole voter population of Techiman South to the total number of valid votes cast, what total will you have?
If you add the whole of Techiman
South
voter population,
yes,
to the declared total number of valid vote cast as per the Electoral Commission's declaration.
Yes. Yes.
You get 49.
I've already asked that question. Okay.
You get 49%.
Now, let's proceed to your summary sheet, the Exhibit E. Before then. Now, subsequent to all these things, the results of Techiman South were declared. Is that not so? And
yes, my lord.
And the total number of valid votes cast in Techiman South was known.
Yes, my lord.
And that number is 99,436. Not so. You can check it from your exhibit, which you have attached. Your exhibit. Attached to your exhibit C as the very first exhibit. Sorry. It's attached to your exhibit C, the first presidential election results summary sheet of the constituency of Techiman South.
Okay.
So look at your exhibit C, and the first document after that, you see it. So you see that it's the same. I'm talking about the total number of valid votes cast.
And it is 97,227?
No, my lord, if you do the actual calculation, you get 99,000 votes. No, yes. My lord, I'm saying that the 99,436 is the actual sum of the valid votes here.
So you are saying that the figures on the exhibit are wrong?
The totals of the figures are wrong, but the specific figures that each candidate obtained is correct. If you do the total, you find out that the total valid votes is...
Then you have to go through that exercise before you are doing what you are doing.
Very well. Now, can you... You can't use the system to confront it. So, can you do the addition? 46,379.
Document are we referring to?
Exhibit C.
Yes. I don't see them. The pink sheet for Techimancha. Okay. Yeah, can we go?
Yeah. Well, the next one is 52,034.
The first one.
For the petitioner.
Yeah.
And then for Christian.
Sorry, the first one.
You start from the beginning of the figures.
Yes. For the second respondent, he obtained 46,379. The petitioner obtained, just add, that's all. Petitioner obtained 52,034.
Yeah.
Christian Andrews obtained 720.
Yeah.
Yvonne Green Street, 46. Ekua Donko, 24. Henry Herbert Latte, 16. Hassan Ayaga, 54. Kofi Percival Apalu, 24. David Apasera, 45. Bridget Jogwenuku, 19. Nana Kunedu Ajiman Rollins, 29. And Alfred Kwame Asiedu Walker, 46.
My Lord, the total is 99,436.
Correct. So now, if you add the 46,379
My Lord, on the face of the pink sheet, the valid votes cast was 97,227.
So does that make the actual valid vote you just got wrong?
No.
Does it make it wrong?
I thought that we're dealing with figures
we are dealing
that have been signed to by agents. If we are correcting the figures, then that is the invitation we give for all of us to sit down and correct the figures.
No.
But if
you see, we are currently in court, so it is for the court looking at the figures to make a determination of the correct figure. And I'm saying that when you do the addition of the actual figures obtained, you get 99,436. Do you dispute that?
I don't dispute that.
Fine, so let's go on.
I don't dispute that.
Now.
But the total indicated is different here.
Kindly ensure you don't speak at the same time as counsel.
Yes, my lady.
Also, when he's giving an explanation, he should be allowed to complete the explanation.
When the explanation has nothing to do with the matter. Very well. Now, so, if you add the total valid votes from Techiman South to...
Please mention the figure that you are referring to.
Okay.
Because as the witness is pointing out to you, on the same form, there is another figure as a different figure as the total valid votes cast.
My Lord,
so refer to the figure that you are.
Yes.
Yeah.
I'm saying that if you add the total valid votes of 99,436, which you have confirmed, to... will you allow me to ask my question? If you add this figure to the actual total valid votes and announce on 9 December, that is 30,121,111, what total do you get?
My Lord, I never heard 13,119 has been announced as you claim.
You see, Mr. Nketia, we have gone through the calculation of the actual figures with you, and we arrived at 30,121,111.
Yes,
so,
my Lord. My problem is
with
the announced.
Please, if you add the 99,436 to that figure, what is the total valid vote?
My Lord, if I may hear the figure so I can
go ahead
for you.
99,436. 99,436.
436, yes. Plus
13,121,111.
13,121,111.
How do you get?
You have 13,220,547.
What? 13 what?
13,220,547. Which is also a new figure.
Yes, my Lord.
But on that exhibit, the total valid ballots is 97,227. And then the total votes cast is 99,437. So which one are you? 436.
My Lord.
And then rejected ballots, 2,209.
Yes, my Lord. This is obviously a clerical error, because if one was to add the actual figures, you will get as the total valid votes cast in Techiman South, the figure 99,436. And the witness has just confirmed that by the calculation, that the actual valid votes cast.
No, but Mr. Akutuampa, that's based on an assumption. Clearly, it is based on an assumption.
My Lord, which assumption?
The assumption as to which of the figures are correct.
Well, my Lord, these are the figures that we have. There are no other figures that they have demonstrated. These are the official figures.
Yeah.
Yes. Yeah, but my Lord, I'm responding to your Lordship's question that these are the official figures. And when you add the votes obtained by each candidate in Techiman South, my Lords, you get a figure of 99,436. So what is down below is clerical errors in doing simple arithmetic.
So if you can remind us, what's the question? If you can remind us, if you can remind the witness.
The question is, if you add the 99,436 to the 13,121,111, what is the total? No. This is let him do it, please.
When I add the two figures you quoted, I had 13,218,896.
Yes, that is correct. Now, so if you add the 46,379 that the first respondent obtained, second respondent obtained in Techiman South, to the figure announced, declared for the second respondent and at the press conference of 9th December, which is which is 6,730,413. 6,730,413.
6,740,000.
730, not 40. 730,000.
6,730,000.
30,000.
413.
413. And you add 46,379. What do you get?
46. 1,379. We have 6,776,792.
So, can you tell the court what that is as the percentage of the 13,218,896 that you mentioned a moment ago?
Come again,
13,218,896.
Yes. 51.
51.267. 51.266. Okay. So you can see that if you were to add the actual votes that the second respondent obtained in Techiman South to his total votes as of 9th December, second respondent would still have crossed the 50% threshold.
My Lord, I wouldn't know, because the figures that we are contesting here, you have the same agents signing onto tallies allocated to presidential candidates and then signing onto totals. My Lord, with respect, we are calling it clerical error. I don't know whether the error was in the totals or the error was in the tallies allocated to the various candidates.
But you see, you do a tally based on the primary figures. Is that not so? You don't do a total first and then from the air, and then you come and fit in the specific figures. Your totals your totals are based on the primary figures. Is that correct?
That's correct. But so, if the primary figures are wrong, the totals will be wrong.
Hold on. So the totals here are the ones we are dealing with, and they come up to 99,436 as you have
the totals
calculated.
Yeah.
Yes.
And Lord, the totals on the various tallies, when you put together, is 99,436.
Yes.
But I cannot test to the validity of the various figures.
That's your problem.
And then the totals, because both the totals and the tallies have been signed onto by the first respondent's representative and the representatives of political parties.
But I'm saying that from these totals, second respondent crossed the 50+ threshold.
Well, from the totals we see here, yes.
And the petitioner was below that threshold. The petitioner obtained 47.396%.
From the figures we see.
Yes, yes, that's true. Now, yes, he said yes, of the figures we see here. That's what he said. Now, again, if you go to 10th December, that is, and you look at your exhibit B, now you notice that if you add the 99 436 to the total of 13,119,460. What do you get? What do you obtain?
The figures again, hello.
You add the 99,436.
99,436
to the total valid votes cast as announced or in the press release of 30,119,460. What figure do you get?
You have 13,218,896.
Very good. Now, can you tell the court now, and if you add the total number of valid votes obtained by the second respondent, that is 46,379 in Techiman South, to the total valid votes obtained on the press release, that is 6,730,587. What figure do you get? 6,700,000.
You are talking about total valid votes.
Yes.
We haven't agreed on which are the total valid votes, so I would prefer you mention the numbers so that I add them for you.
Okay. If you add the 99,000. 99,000. If you add 99,436 to the total number of valid votes of 13,119,460 as in the press release, what do you get? Press release of 10th December.
You have 30,218,896.
So now, if you add the total number of valid votes obtained by first respondent of second respondent of 6,730,587 to the total number of valid votes he obtained in Techiman South, which is 46,379. What do you get?
My Lord, as I said, let me mention the figures and let me add for you, because what is the total valid votes business is still in contention. So just let me have the figures and I'll add them for
you. The figure is on Exhibit B. The second respondent obtained 6,730,587. That's your Exhibit B.
87. Plus
46,379.
46,379. My Lord, it gives a total of 6,776,966.
Good. Now, what is this figure you just mentioned as a percentage of the...
Are you not taking us back?
No.
Okay,
no, my lords. What I did originally was to add the total votes for 30-man South, all of it, to the petitioner. What I'm doing now is the actuals. That's what I'm doing now. Now, so what is the percentage of the 13 million, of the 6,776,000?
13 million.
96, yes.
I have the 6 million figure, but I want to hear the 13 million.
The 13,218,896.
%51.267%.
And when you add the 52,034 to the total valid votes of the petitioner, as in your Exhibit B, which is 6,213,182.
6,213,182. 182. Plus
52,034. 52,034.
34.
Yes. What is that figure?
6,264,216.
And what is the percentage of that figure? What is that figure as a percentage of 30,218,896?
30,000,000. I beg your pardon.
896.
896. 47.388.
Now it's 47.396. Do it again.
Let's go over your figures again.
So, oh. Very well.
Very well, my lord. Yeah.
So, my question.
No, you say we should do it again.
Yes.
Yeah.
So, add $52,000. And I said it was not. I said it was. No.
Accepted, then added for a
percentage, yes. Okay. So, what is the percentage of the figure you obtain of 13,218,896? The figure you obtain as a percentage of 13,218,896. Yes. the figure you mentioned, well, that's why I wanted to do the addition again.
I'm really worried about her not getting the records. So, Asiedu Nketia, the last thing you said, you didn't speak into your microphone.
So, second petition, the petitioner obtained 6,213,182 in the press release of December 10. So, when you add to that figure 52,034, what is the total? 52,034
plus 6 2 and 3 1 8 2 6 2 6 5 2 1 6 1 47.396.
Correct. So here again, when you add the actual votes obtained by the two candidates to their total votes as published in the press release, second respondent crosses the 50+ threshold.
We haven't agreed on the actual votes.
No, but I'm saying that in terms on the face of the documents, second respondent crosses that threshold.
On the face of this press release? Yes.
And on the face of the document, the petitioner obtains a meager 47.396. Not so.
My Lord, the figure on the face of this document, 47.396, I can't tell whether it is meager or not.
I'm happy that your concern is only that it is not meager. Now let's look at your summary sheet of the 275 polling stations that you've attached as Exhibit E to your witness statement. Constituency, the 275 constituencies. Yeah. What's that one? What's that? Now, you will notice that at the tail end of that exhibit, you find the summation of the total figures of votes that each candidate obtained. And you also indicate what, from your calculation, each candidate obtained. On the side, that there's a difference of 568.
Yeah. Yes, my lord.
That's all. Now, so let's look at the total valid votes obtained by the second respondent on that spreadsheet or summary sheet. Yeah. It is 6,776,065.
My lord, it's 66. I see 66 here.
66, sorry. Is that correct?
Yes.
And the total number of valid votes obtained by the petitioner is 6,265,276.
Yes.
Correct. And
6,265,276, yes.
Yes. And from the EC's calculation, based on the EC's total valid votes of 30,218,600. What is that? No, my lords, that is the NDC. The last column is the NDC's votes. The EC's calculation of total valid votes is the column 1, 2, 3, 4, 5 from the right. That is the EC's calculation.
And the total valid votes.
Yes, total valid votes, yes. And the number, the figure there, my lords, is 13,218,633.
Yes.
Yes. Now, you find that from the EC's calculation, 6,776,000 and 66 yields a percentage of 51.261. Correct?
I will declare it up.
Excuse me.
I didn't understand the question.
I'm saying that if you look, it's your exhibit.
Yeah.
And I'm saying that from that exhibit, the total valid votes cast overall, according to the EC, is 30,218,633. That's the document. That's what you have.
13,218,633.
Yes.
Yes, and this is different from what was announced and what was corrected and what was subsequently corrected.
Please, hold on. So, I'm saying that 6,776,000 and 66, which is the total valid votes obtained by the second respondent, as a percentage of the overall total valid votes of 218,613, sorry, is 51.261. 261%.
That's correct.
Yes. Now, you claim you did your own calculations of those figures. And by your own calculations, you claim that the second respondent obtained a percentage of 51.263 of the total valid vote cast. That's your calculation. You see it at the last column, at the bottom, the very last column.
Yes.
So
51.264.
263.
263.6759.
Okay. So I'm putting it to you that whether it is the EC's calculation or your calculation, definitely second respondent crossed the threshold.
If we are going by the data supplied by EC.
Yes.
But the data is internally inconsistent.
Now, let's now come to your exhibit. Your exhibit C. The council, no.
He was
struck out.
Struck
Yes.
out, yes. So.
Yes. Now let's come to your exhibit. Your exhibit D. Now, your exhibit D is your famous letter,
yes,
of complaint to the chairperson of first respondent.
Yeah.
Where you claim that the results which were collated and signed by all the parties were not the ones transmitted from the region to the Electoral Commission's offices in Accra. And your second allegation was that Ashanti... No, my lord, I'm talking about the letter, Exhibit D.
Was the letter addressed to you? Was it addressed to the second respondent?
Yes.
This letter?
It was addressed to the first respondent.
You go on, go on.
Now, you said two complaints, complaint A and complaint B. Complaint A is that in the Eastern region, the results in the presidential elections which were collated and signed by all the parties were not the ones that were transmitted from the region to the EC's offices in Accra. And the second point, B, relates to Ashanti region. Say Ashanti region provides fundamental problems that require investigation. We have found out that almost across board, the aggregates on the summary sheet do not reflect the individual results on the pink sheets. Further, the results collated and declared for the region do not reflect the aggregate results on the pink sheets in our custody. Now, it is a fact that you wrote this letter on 9th December. And I believe 2020, is that not so?
Yes, 9th December 2020.
And I understand from your position that you wrote this letter before the declaration was made.
Yes, my lord.
Now, your complaints about Eastern region have already been disposed of by the Council for First Respondents, so I will not go there.
My lord.
Yes. Yes.
My complaint about Eastern region still stands.
Well, okay, that's fine. Now, if you go to your complaints about Ashanti region, which you had made before you filed your petition, you notice that in your petition, you say absolutely nothing about this alleged complaint. Absolutely nothing in the petitioner's petition. Do you agree?
If you are not careful, the recording
You are doing the same thing. It's here. It's here. Huh? Do you agree?
My lord, we're referring to those complaints under the cooked figures, which has been
please,
struck out.
you don't listen to my question carefully. I'm saying these allegations you make about problems in Ashanti region, when you filed your petition after this letter, when the petitioner filed this petition, the petitioner said absolutely nothing about these alleged problems in Ashanti region. You admit that?
My lord, we referred to cooked figures, and it was...
No, I'm talking about...
We didn't mention this specifically, but we referred to cooked figures, and that was where...
And Mr. Nketia, in your own witness statement, you never mentioned any difficulties you had with Ashanti results.
My lord, we attached some sample constituency figures. Some of them are from Ashanti, and we indicated that they were not correct. So, but they were put into the results that was declared. So we selected some sample constituencies, which include constituencies from Ashanti region. And that was to prove our case that there was a mismatch of figures in Ashanti region.
Now, so you will see that you'll see that whatever complaints you made about Ashanti region were so minor and insignificant that they did not affect in any way, in any material way, the results as announced by the first respondent, whether in the declaration itself or in the press release or when you added the actual votes obtained in Techiman South, or when you took
Ashanti region to Techiman South.
Sorry.
We've warned you, we don't want double-barreled questions. The questions are overloaded.
So I'm saying that these complaints that you make assuming them to be valid, they had absolutely no consequence for who crossed the 50% threshold in the declaration of 9th December.
My Lord, I disagree.
So, we'll come to your disagreement. I'm furthermore putting it to you that in the same manner of function, they had absolutely no material effect on the winner as published in the press release of 10th December.
My Lord, I disagree.
Nor did it have any effect if you took the actual votes obtained in Kechiman South.
My Lord, I disagree.
It did not have any effect if you added all the total voter population to the second respondent, to the petitioner. Second respondent would still have crossed the... Yes, you added it to the votes of the petitioner. Petitioner South. If you added that to the votes obtained by the petitioner, it still would not have made any difference as to who crossed the 50+ percent threshold.
My Lord, I disagree, because if you are adding one correct figure to a wrong figure, you cannot end up getting a right answer.
Now, let us look at your Exhibit F. Your Exhibit F. In your Exhibit F, you claim that there has been padding in the total sum of $4,693. Not so.
My Lord, that is not our claim. Our claim is that there have been voter pardon, and we have samples to show that there was voter pardon, and that was what we demonstrated. So we have in no way indicated.
Please respond to the question. You can add explanation.
We haven't claimed that 4,700. The figure stated there is the total number of votes that were pardoned.
So I'm saying that in respect of your allegations of pardon, the only document before this court is your Exhibit F. Is that correct?
That's correct, my Lord.
And I'm saying that if you go to Exhibit F, you will discover that the total figure that you allege were pardoned is 4,693. That's what I'm saying.
That is not correct, my Lord. We said that is a sample. No, so the totals in the sample is what you have mentioned.
He is referring you to the exhibit which is before the court. Respond to it.
I've already said so.
Well, the exhibit was attached to a witness statement, and the purpose of the witness statement was clearly stated. The purpose of the exhibit was clearly stated in the witness statement.
Now, you see, the figure that you have here, simple question, is 4,693.
Yes, my Lord.
And you notice, so when you attach this figure, did you do it with the consent of the petitioner.
My Lord, I was to testify about matters that were in my personal knowledge.
But you were supposed, you said here that you had come to support the case of the petitioner. Is that not so?
That is so.
So my question is the case of the petitioner that 4,693 votes were pardoned? Is that what the petitioner said in his petition?
The petitioner said there was a sample.
No. Please answer my question.
Please, let him answer the question. You see, let him answer the question. If the answers appear not to satisfy the court will certainly raise issues. So you let him answer.
Respectfully, the question was, it is a case of the petitioner that so and so. And he started an answer. That, so he should be allowed to answer.
No. You see, your petitioner mentioned a specific figure in his petition. Is that not so? It's not that the vote pardon. Yes.
My Lord, the figure mentioned by the petitioner as vote pardon is a sample of the vote pardon, that is to demonstrate that there was indeed widespread vote pardon.
What was that figure?
Well, if I can refresh my memory. Petitioner. Exhibit F. Exhibit F. Yeah. I see 5,662.
So when you published in your, or you stated in your witness statement, a lesser figure, was it with the consent of the petitioner?
Yes, my Lord, because each of the two figures are mere samples just to demonstrate a fact. That is not supposed to be any absolute figure. So some samples could be selected, and under time pressure, if you look at the petition and my witness statement, where we're talking about the samples of constituencies also, the petition mentioned 31 or so constituencies, but we ended up bringing 26, the samples of 26 constituencies because of the time pressure that we needed to submit our lesson. But since they were all samples, it didn't matter to us very much.
Now, Mr. Asiedu, you see, Now, Mr. Asiedu, now, if you were to, you claim that there was vote padding in favor of the second respondent, and the figure that you have supplied is 4,600 plus and 93. Now, you see that the petitioner himself attached documents claiming that the vote padding was in the figure of over 5,600. Yes, in Exhibit F, 5,600 and 5,662. That's what the petitioner himself has said. Do you agree? Now, I'm putting it to you that the reason why you have revised that figure from the 32 constituencies to now 26 is that you've realized now that those other constituencies, the figures were in your favor. The so-called vote padding was in your favor. So when you were filing your witness statement, you took them out.
I disagree, my lord.
Now, let us still stick to your exhibit. You'll see that your exhibit F has a pen drive copy. Not so.
I don't see it attached here. I don't see it on my file. Yes, my lord. I've seen it.
Now, you will see that in that pen drive copy, which we'll ask the court to play, you see that there are columns where you indicate padding for NDC. That is not shown on the hard paper, but on the pen drive, that gives a fuller picture. There are columns where you indicate that padding for NDC. There are other columns you indicate that padding for NDC and NPP, and other columns that you indicate padding for NPP. Is that correct?
My lord, that will go to the heart of the credibility of the figures as
I'm asking you whether that is correct.
Respondent. The question again.
I'm saying that the pen drive information is different from the hard copy you have attached. Is that correct?
A pen drive attached to the petition.
Yes. The exhibit F, the pen drive of your witness statement, from which you create the hard copy exhibit F. you notice that what is in the pen drive is not fully what you have as Exhibit F.
Well,
the hard copy. The hard copy and the pen drive.
A hard copy of Exhibit F.
Yes.
And the pen drive.
Yes.
My Lord, I have not discovered any such discrepancy.
But Mr. Nketia, have you looked at the pen drive? Yes, you.
I looked at the hard copy.
No. Have you looked at the pen drive? Don't answer questions that you are not asked.
No, I haven't looked at the pen drive.
You haven't looked at your pen drive?
No.
Good. Now, my lords, if it is possible for us, yes, to play it, to show it.
Can it be expanded? Mr. Kusambo, the document has been opened.
All right. So, you see that if you go to Asante Akim North, that is the 1, 2, 3, 4th entry on Asante Akim North, you see by it, in brackets, padded both. Padded both. Asante Akim North. That's the third, or is it fourth? Yes. You see that there's brackets, padded both. He doesn't know how to do it. You can't go there. You can't go there.
Check the floor. This one check the floor down.
Yes, my lord.
Because help us. When we look at it, we couldn't find it.
My lord, I didn't hear you. I'm sorry.
There's nothing.
You see, Mr. Technician, I believe the folder is padded. Have you opened?
The name of the folder is padded.
Yes, you opened it. So I'm putting it to you. I'm putting it to you that in respect of Asante Akim North, your own document admits that it's padded on both sides. I told this, I raised this question.
My Lord, I can't see what he wants us to read. Where it is indicated that it's padded for both sides and all that.
Yes, my Lord. My lords, is it possible that we can get a technical person to assist the technician? Because he needs to open the folder properly, and obviously he's not able to do so.
26.
Because this is their exhibit, my lords. It's not ours, it's theirs. And we are saying that when we opened it, we noticed these observations.
But those observations are not being shown here. Those observations that you saw are not here, are not appearing here. Is that what you are saying?
Yes. Yes, because they have not opened the folder correctly. That's the point we are making.
Yeah. Is there any problem?
My Lord, that folder is named 26 constituencies. The folder that he has to open.
Mr. Kwanzaa, council is giving you direction. He said it's called something.
26 constituencies. My Lord.
Yes.
Mr. Kutampa, which file should he open within the folder called 26 constituencies? He says there's a folder named 26 constituencies. Within it are several files. Which file do you want him to open?
Open the 26 constituencies.
The folder?
Yes.
And that all the files in there will just reflect as files, you know.
We believe so.
Mr. Kwanzaa, that's what he wants.
Yes, your Lordships, in this particular folder with the subtitle padded, if you open it, there are about 26 constituencies with names in there. For example, the first one at the top, Ablekuma West, they've written padded beside it. Ifijai Kwabre South, padded. Asante Akim North, padded both. Antiwanyu Abiedia North, padded. Ayawaso East, padded. Ayawaso North, both NDC and MPP, padded. Cape Coast North, padded. Ejisu, padded. Gomwa West, padded. Gushegu, padded. Kita, padded. Ketu North, padded. Koliklote, padded. Miom, padded. Nadoli, Kaleo, padded. Nandom, padded. North Dine, both NDC and MPP, padded. Okaike North, padded. Okaike South, padded. Savelugu, padded. Savelugu again. Sangreligu, padded. Sunyani East, padded. Tain, padded. Tamale North, padded. Time.
Now you are expanding it.
Then Tema East, both NDC and MPP, padded. And finally, Upper Manya Probo, padded for NDC.
Mr. Kusampo, the day is fast spent. Can you ask your questions now that it's open?
Yeah. You see, Mr. Nketia.
Yes, my Lord.
on the pen drive that you've attached as Exhibit F, there are certain constituencies that you simply say padded, and there you mean padded in favor of MPP. But there are some constituencies where you say both padded, you mean padded for both NDC and MPP. Is that not so?
My Lord, as I indicated, this is my first time of seeing it.
But it's your evidence.
It's exhibits. There is a hard copy and there is this electronic copy. And I was, frank to tell the court that I haven't seen it. And you are showing it, and I don't see any padded NDC MPP on the screen.
Are you saying that there's no such description?
I've never seen it. Counsel. Yes.
But it is your exhibit. Excuse me. So I'm putting it to you that in your exhibit you have these markings. Padded, both padded for NDC and MPP. I'm putting it to you.
Well, you have seen it, and so I am unable to admit or deny, because I honestly told you that the electronic copy, haven't seen it, and that is the reason why it was displayed. And I don't see, from where I sit, I don't see padded for NDC or padded for MPP on the screen.
Now, you see, if you take, I'm putting it to you that these so-called padding and non-padding or both padding occurred at different constituencies. You agree?
Well, if you say so, my Lord.
Now, I'm putting it to you that it could not have been a grand plan of the EC to pad for both NDC and MPP.
I disagree, my Lord.
You think they will pad for both?
Look, my Lord, if I may elaborate further.
No, I'm asking, you are saying they'll be padding for both? Please.
The witness is about to answer the question. Is interrupted.
We are waiting for him to answer. It's all right. We are waiting for him.
My Lord, if 10,000 votes are added to one tally, or the tally of one person, and 200 are added to the tally of another candidate, it will create the false impression that the two candidates' tallies have been padded. But the impact is completely different. So if we talk about padding in favor of a candidate, that is precisely what could happen. And so the fact that on the face of the numbers, it could happen that in one party stronghold, if there is a grand plan to pad for his opponent, he could artificially add some votes to the tally in his stronghold and add more votes to the opponent, and it will create the desired impact that they intend to achieve. So padding cannot be established merely by comparison of those total figures at the end. If in Ashanti region, MPP leads by say 1 million votes, and you add 500,000 votes to NDC's tally, NDC's MPP will still be in the lead. But then you have reduced the impact of that lead by adding votes. So once you see that the figures are not reconciling, then we go back to the table and then look at what is wrong together.
You see, Mr. Nketia, the figures that are at play are only 4,693. According to your own...
Ask this question.
My Lord, I'm going to follow up. That's why I'm making that up. Now, I'm putting it to you that if you were to if you were to deduct the 4,693 alleged padded votes from the second respondent's votes as declared on 9th December, that is 6,730,430. If you were to deduct the 4,693 from that sum, you get 6,725,720. I'm putting it to you.
My Lord, that is so, but that arithmetic is meaningless.
Hold on. And if you use 6,000, you calculate 6,725,720 as a percentage of 13,121,111, you get a percentage of 51.259. I'm putting it to you. Excuse me.
What's the question? My Lord, I want to take the question again.
I say, if you deduct your alleged padding from the total number of valid votes that the second respondent obtained by the declaration of 9th December, you get a sum of 6,725,720.
My Lord, arithmetically correct,
is it correct?
But it's meaningless because we are talking about samples being taken
Answer
away.
the question.
You
Answer the question.
My Lord, I've answered that.
Yes.
That is correct, but it doesn't.
Now,
it is meaninless.
Now, what is 6,725,720 as a percentage of 13,121,111, which was the number declared for second respondent on 9th December. What is the percentage?
My Lord, I'd like to hear the figures again and do the calculation and give you the answer.
So, the original figure is 6,730,430.
Please, slowly. 6,730,413. 413.
Subtract from that the 4,693. What do you get?
Minus 4, 6, 9, 3. You get 6,725,720.
Yes. Now, what is that figure as a percentage of 13,121,111.
13,121,111. 51.259.
So you see, Mr. Nketia, that even if you were to deduct your alleged padded vote from the vote of the second respondent, he still crosses the 50 plus threshold.
I disagree.
Well, that's your maths. Now, again,
because samples cannot be subtracted from another population figure.
Now, on 10th December, in the press release, the total valid votes obtained by the 12 candidates is 13,119,460. That's correct, isn't it?
My Lord, let me go back to my attachments.
Yes. So, now, here's the thing. If you subtract 4,693 from the total votes obtained by second respondent, that is on 10th December, which is 6,730,587. 6,730,587. If you subtract that from 13,140,000, what do you get first? You get 6,725,894. That's the figure you get when you do the subtraction.
I thought you were mentioning the figures for me to do the calculation.
No. So do the calculation.
Please, what are the figures?
6,730,587.
Yes.
You subtract from that 4,693. What do you get?
4,693. 93. You get 6,725,894.
Yes. Now, what is 6,725,894 as a percentage of 13,119,460?
119.
13,119,460.
%51.267%.
Okay. Now, so there again, second respondent crosses the critical threshold.
I can't tell, my Lord.
Now, if you, we've already done this, but this is simply to aid you, that if you add the total of Techiman South voter population to the valid votes of 13,119,468, that is, if you add 128,028.
My Lord, slowly, because you are asking me to add. The way you are.
128,002.
Can we start, sir?
I thought you had left Techima South long ago. And you are taking us back.
Yes, my lord, you see, there are different stages. I'm demonstrating that even when you withdraw, you take out this alleged thing. Yes.
Oh, but did you not cover that?
Oh, very well.
I thought,
so I'm putting it to you that when you withdraw or subtract the 4,693 from the total valid votes obtained by second respondent, whether as announced in the declaration of 9th December or in the press release of 10th December, or when you add the two, in all these occasions, the second respondent still obtains over 50% plus.
My lord, here again we are attempting to take mangoes from apples.
Now, the critical question here now is that however and whatever the number of total votes, valid votes you take, and the number of valid votes oh, very well, I'm happy your lordships get it. Now,
we don't follow the proceedings. Then why are we here?
Now, you will see from the petitioner's petition that, that ground A of the petition suggests or states that the declaration on 9 December violated Article 63(3) of the Constitution and is therefore null and void. Is that not so?
Yes, my lord.
Now, we all know that Article 63(3) requires a person to have more than 50% of the total valid votes cast to be declared president. Is that not so?
Yes, my lord. I've been advised my lawyers that that's true.
And I'm saying that from all the evidence before this honorable court, second respondent, in whatever situation, crossed that threshold. That's the evidence before this court.
My lord, I disagree.
Have you produced any evidence to the contrary?
My lord, I indicated that we are here with the figures as declared by the first respondent, and we are questioning the internal consistencies of the figures.
You have not answered my question. I'm saying, have you produced any contrary evidence of the total number of valid votes that the second respondent obtained, showing that he obtained votes below the 50%? Have you?
My lord, because those figures are not available.
Good.
Are not available from the declaration by the first respondent. And we are not here to bring figures here because we don't have a constitutional duty to declare results of elections.
Very well. So you can come to the court to challenge the validity of the results of the presidential elections without any evidence of what the actual results were.
My Lord, if I know that 2 plus 2 is 4, and I'm presented with results that indicate that 2 plus 2 is 6,
Excuse me. Please answer the question. At times you try to be a bit sarcastic. That is not done in the courtroom.
Yeah.
Yes. Mangoes, manos, whatever. You don't do this in under cross-examination.
The power interface will learn. And so the power interface are trying to catch up with court procedures.
You were a teacher, a banker, a politician,
a teacher, banker,
of one of the largest political
farmer, block maker, and a distiller of Apetesi.
You see? So I'm saying that you are telling this court that you can come before it claiming that the second respondent did not cross the 50% plus threshold without producing any evidence to show that. That's what you are saying. Because that's your ground A.
We have supplied evidence from the first respondent who is supposed to make those declarations, and we brought them here to challenge the validity of those declarations.
So that's how you arrive at the fact that second respondent did not cross the threshold.
Because the data obtained from the
Is that
first
how
respondent.
You arrive at the position that the second respondent did not cross the threshold as required by the Constitution?
My Lord, the figures are what we base our submissions on. Because the first respondent who is supposed to declare has put figures there. You look at the figures, and the conclusion is that the second respondent did not cross the threshold.
Because you use the total votes cast. Now, again, your ground B is founded on an alleged violation of Article 2.3 and Article 296 of the Constitution. Now, I put it to you that you have not produced any substantial evidence that these alleged violations, even if true, affected the actual votes obtained by the candidates. Even assuming that there were violations of the petitioner's right to be heard fairly and so on, you have led no evidence to show that those violations had an effect on the actual votes that second respondent obtained and the actual vote that the petitioner obtained.
I disagree.
Now,
just to be clear, you refer to a second relief. What I'm seeing in our second relief is not quite the same as what I...
Very well.
And you see where is it? That your ground C and D are simply a rehash of your ground B. So Nketia, I'm putting it to you that your petition, your petitioner's petition, shows no reasonable course of action. Please. And I'm putting it to you further that you are not, the petitioner is not entitled to any of the reliefs that he seeks. And you have no case worthy of hearing before this court. My Lord, I'm done.
Yes, yes, please, there will be a question from the bench.
I want to be very clear on some issues. General, I know that when you purchase a pen drive, it is empty. And the data on any pen drive is generated by someone. So the pen drive that you attached to the hard copy and exhibited as Exhibit F, who generated or placed the data on it? Because when you were asked, you said you don't know what was on it. Who generated the data on the pen drive?
My Lord, as I said, honestly, I hadn't seen the pen drive and its contents till today. And I was relying on the hard copies. But the evidence is gathered by our Elections Directorate and the Legal Directorate.
So they gave it to you and you exhibited it as part of your evidence?
No, my Lord, I did not exhibit that document.
As part of the petition, he did not exhibit it. He made it quite clear. Exhibit F.
Statement.
So he swore on oath that it's for him, and he brought it to us.
He exhibited it. So I want to find out who generated it. So it means your election generated it and gave it to you and you exhibited it without seeing it.
I read all the hard copies of the document because of the time pressure. I was discovering this thing today.
Okay,
so that's why I indicated that I haven't seen it.
Then I want to be very clear on these issues too. Very, very important to me. Now, in all the figures that were mentioned as the valid vote cast and all those things, you were saying if the figures were correct, and that there were inconsistencies in the figures, I want to ask you, now, in your own calculation, what were the total valid votes cast in the presidential elections on 7 December 2020? In your own calculations.
My Lord, those calculations are reserved for a meeting for us to reconcile the figures because the first respondent herself keeps changing the figures. And so it says, when you bring your...
Excuse me, Mr. Asiedu Nketia, help the court. You see, when you started giving evidence, you said you had all representatives across the 275 constituencies. You said you put agents as, to use the... Yes, and they were to, collect the figures. You said it. Then he's asking you that from that, what figure did you get? You.
My Lord, I haven't brought that figure to court.
Okay. Then, from your own calculations, what were the valid votes cast in favor of the petitioner, to your knowledge?
My Lord, when we discovered this discrepancy, it was difficult to even know which figures are.
You don't know, you just answer. You don't know.
I don't have them here.
Okay, then the last one. What figures from your own calculations did the second respondent get as the total valid votes cast in his favor?
My Lord, I don't have those figures here.
Thank you. That's all.
Mr. Asiedu Nketia, you have referred on a number of occasions to data being internally inconsistent. Can you explain what you mean by that? The data on the basis of which you have been cross-examined. You have kept saying the data was internally inconsistent.
My lords, there's no ambiguity in that statement. Nothing has been said here that suggests that there's no understanding of that statement. The statement is clear in its terms, so he cannot be asking him that question under re-examination.
My Lord, I believe the purpose of re-examination is to clarify matters that came up in the context of the cross-examination. So when the witness keeps saying that data is internally inconsistent, I believe that there is a need to explain.
My Lord, my understanding of data that is internally inconsistent is where figures are given and a total is given which is different from the sum of the figures. As we had on the declaration sheet for Eastern region, for instance. What, my Lord? He hasn't finished. No, my Lord. The answer is that data, which is, if data is given and a total is also given, and when you add the totals, you add the data, raw data, it doesn't agree with the total as given, then the data is inconsistent. And I'm citing an example of the Eastern region collation sheet. My Lord, it was said in court here, we tendered two different documents. One was done
you see, this
on
is just
6:40 p.m.
Excuse me. You want to elicit an answer to a very simple question for him to explain inconsistency in data. But going back to Eastern region and flipping through the exhibits, yes, are you looking for fresh evidence? He wanted just a simple answer for you to tell the court what is, yes. That's all.
My meaning is that when there is data,
we've got it, thank you.
And there is a claim that the data adds up to this, and when you actually add, it is different from what the total is claimed, then that data is internally inconsistent.
Mr. Asiedu Nketia, in connection with the cross-examination of counsel for the counsel for the first respondent, he drew your attention to something from Ayen Swanu, and he related that to the calculations that he had asked you to make. Now, how does the Ayen Swanu
my lords, I object to this.
Well, counsel for first respondent referred to Ayen Swanu in connection with the documents that he cross-examined you on.
Yes,
and my question simply is, what is the relevance of, can you explain the relevance of Ayen Swanu? My lord.
My lord, this is fresh evidence. We can't take it.
I'm sorry.
I want to think about understanding the rules.
Yes.
Thank you, my lord.
Oh, yes.
Or what? Okay.
It's off record. You didn't tell us your other name. You did not tell us your other name. Your alias, which begins with the rank in the army. You didn't tell us your alias, which begins with the rank in the army.
My alias?
Yes, which begins with the rank in the army. Or you don't want us to take judicial notice of that?
My lord, I thought Justice Apau prefaced his question with that.
Because you come from his hometown, that is why.
I'm known as General Mosquito. That's my alias. Very well, my lord, if you request. Thank you very much, Your Lordship.
The case, sorry, the petition is adjourned to tomorrow at 9:30 a.m. Yes. For the next witness.
All rise.
It's been another contest between Mr. Akufo-Addo's lead lawyer, Akoto Ampao, and Mr. Mahama's first witness, Johnson Asiedu Nketia, in this cross-examination. Questions: was a fatal inconsistency exposed? Was the witness' credibility exposed? Oh, did Akoto Ampao test the petitioner's case and prove it was wrong, unreliable, unattainable? Well, the law, it is said, is in the bosom of the judge. We will wait for the 7-member panel's decision. But it's been a very long day, very long hours. It appears in all we've done close to about 5 hours, Kojo.
We have indeed. And I've got to say, for the last 2-hour stretch, the most fascinating moment for me was when the judges took a moment to ask a few questions. And I think it started to let us see perhaps how the court will be viewing the outcomes of all of these exchanges in order to make their ruling, their judgments at the end. And I think one thing is clear. They want to know what you are bringing to court for them to judge. They want to know what evidence you are bringing to court to make your case. And I noticed they were stressing on specific details. They wanted to know what are the NDC's own figures? What are they calling the outcome or the correct outcome? If they are identifying incorrect ones, what is the correct one? I could see that to be perhaps what the court was seeking to clarify. In the end, the witness had to say that he didn't have those details with him. And I don't know what that means. I don't know whether that in any way affects how the court will look upon the case that the petitioner is bringing. The fact that the petitioner is not himself testifying has again demonstrated its significance, because there are a number of things that in Mr. Akoto Ampao's cross-examination he sought to clarify, which appeared to be something that the petitioner would have to address. Even though this witness is one that is testifying on behalf of the petitioner, it was quite clear that there were certain things that the petitioner, the witness considered the petitioner a better person to address. So once again, the fact that the petitioner himself is not the one on the stand has proved to be significant, interesting. We will see how it affects the final outcome.
All right, so today's proceeding has ended, at least in the courtroom, but as we have learned today, what happens outside the court, especially where lawyers involved in the case are concerned, is also crucial. So who will address the media on behalf of the second respondents? As we've heard, and also seen, Frank Davis, the man who usually does it, was cautioned. The court said it was uncomfortable with his utterances and that it breaches the rules of the legal profession. Who will your money be on? Who's going to be addressing the media?
I wonder. Well, I mean, there are a number of people who could do that, people who are not on record as, advocates for the second petitioner. Even Kojo Nkrumah, who is a spokesperson for government, often attends court. I've seen him there a number of times. I wonder whether he will be interested in taking up that role of communicating to the press on behalf of the team, on behalf of the side of the second petitioner. But yes, I think the court has made it quite clear that they've been paying attention to what's happening outside their courtroom, and they take a view of what lawyers are saying when they leave the
Could it also be that they were probably watching Newsfile because that issue was, came up strongly? There was Dennis Jima, who was on the show, who actually did say that perhaps the court, should caution lawyers on the case.
Yeah.
There were also some words to those lawyers who are not necessarily part of this case in the courts. So Justice Anini Yabua, on behalf of the courts, made a passionate appeal that if you are a lawyer and you're not actively participating, put down your robes and grant the interview. That in addressing the media, one should not be in robes with the wig on.
Fascinating. Fascinating. And again, I mean, I've always wondered about these robes and wigs, and but it's a tradition that's particularly Justice Inini Abua, as the Chief Justice, respects and reveres, certainly wants to keep in place. So yes, you can understand why they would take a view on that. I personally, I mean, I wish.
All right.
I wish.
Kojo, you are right. Kojo Ponkroma is addressing the media on behalf of the second responder. We will listen in.
So let's know when you're ready. Yes. You are? All right. So good afternoon. I'm very sure you have followed the proceedings in the wells of the Supreme Court from morning till afternoon. We are of the view that it's been a good day in court, and that today the big word is exposed. Exposed. You'll notice that counsel on our side spent a lot of time exposing the inconsistencies and sometimes even outright falsehoods that have been put out by the petitioner and the witness who was in the witness box today. So when you juxtapose the earlier claims of we won now to what they are saying in the witness box about they don't know who won, when you juxtapose that to some of the tapes we played about claims of 51% on their side, now to claims that they did not even bring numbers to court, if you juxtapose that between their petition that talks about vote padding of a certain number and now a claim that it's only samples of that number, one of the first things that counsel on our side sought to do today was to expose the inconsistencies and sometimes outright falsehoods that have been peddled by the petitioner and the witness who was in the witness box today. Our counsel also spent a lot of time exposing the bad faith and prejudice with which the petitioner and his team have approached the work of the Electoral Commission and the chair of the Electoral Commission, ab initio. And that's why you saw them take time to set out right from her appointment, from registration, etc. And the belief on our side that this is just a culmination of the various attempts to undermine an otherwise very good job that has been done. Also exposed through very vigorous cross-examination is a claim that was being made that nobody actually won this election. And that's why you saw the Venerable Akoto Ampao over and over again now raise the numbers and ask the witness to do the computation. And if you fry it, you bake it, you turn it upside down, you cook it, it is still 51% plus for the second respondent and about 47% for the petitioner. And you saw him do the maths and admit himself in the witness box when he was under oath. What we also found interesting were the attempts to shield the witness by his counsel to an extent that even materials that they had tendered in, there was an attempt to ensure that he was not questioned on it, even at re-examination, attempt to adduce fresh evidence. But I think you saw how the court handled it. The very final exposure we saw today, an exposure on the lack of candor. You heard the 3 questions that the bench asked. That for all that you have said, when you finished your collation, what were your results? When you finished your collation, what were the results that the petitioner got? When you finished your collation, what were the results that the second respondent got? And it was, I believe it will be very surprising to the millions of NDC supporters across the country who were egged on by the same team that they had numbers to prove they had won. Now here in court, when the bench asked those questions, they say that they did not come to court with any of those numbers. They are not still able to put any numbers before the court, despite all that they had said. So for us, in summary, we're of the view that it's been a good day in court. You saw the lack of candor when on the soft copy on the pen drive, they had made notes that they observed what they call padding, both for the MPP and the NDC. Yet they had claimed that there was a deliberate attempt to steal this election for the MPP. And now in their witness statements, they sought to delete those ones out. And then when it was put to our very good friend, the general, he now said he was not responsible for the pen drive, etc. So that exposure of the lack of candor is also one of the things that our counsel sought to do. In conclusion for us today, our view is that if your case is bad, even the most skillful general will be exposed at cross-examination. And that's what we believe has happened today. If you have questions, we'll take them now and then we'll wrap up.
Your side sought to tender in exhibit through the petitioner's witness. They were opposed to it. Why did you want to do that when you had not asked the leave of the court first?
Well, so that will be a technical legal matter. The substance of it, however, is that what we wanted to show was still in the video that had been submitted. And so you saw our counsel find an opportunity to now cause the witness to do that calculation and express it as a percentage. And no matter how you do it, it still comes back to that same point. The second respondent, 51% plus, and the petitioner, about 47%. Any other questions? Well, we thank you. We'll do a quick translation in Twi, and we look forward to tomorrow's engagement in court.
And that's Kojo Nkrumah. He's actually one of the designated spokespersons on this case for the second respondent, Nana Addo Dankwa Akufo-Addo. In all, he says, exposes the word for them today, out of today's hearing. Good day in court, Kojo Singh. That's what Kojo Nkrumah says. And he actually settles on those three questions that Justice Enini Yeboah put to the witness today. In your own calculation, what was the total valid vote cast? What figures did Mr. Mahama get? What figures did Mr. Akufo-Addo get? And we know the answer to that. He says he didn't carry the figures with him.
And who compiled the data on the pen drive? Another question that was not answered by the witness. Well, the witness did answer. Said that he hasn't had the opportunity to go through the contents of the pen drive. So yeah, I mean, what else would you expect?
It's been brief today.
It's been brief. It has. I think perhaps that might also be more of the style of the person who spoke on behalf of the team. Kojo Nkrumah does tend to prefer to get straight to the point. And his predecessor was a bit more of a storyteller, a bit more of someone who would elaborate on issues. Mr.
Also, maybe perhaps tolerated a lot more questions.
Perhaps. I think today it did appear that he called for questions. It didn't seem as if there were any forthcoming, because he did say, "Are there any questions?" But then that was a wrap very quickly after that. Where I suspect that the EC chairs, the EC's lawyer will be next to speak. But I think in focusing on the questions that the judge asked, another thing that it does is that it moves the commentary away from us versus them to, well, this is what the court is after, And I suppose in a certain way that's also good, strategy-wise, for the second respondent's team, because what it means is that it's not even us saying this. We are not asking you to believe our interpretation of what happened. We're saying, look at what the court was asking for. Look at what the court was saying. In terms of communication strategy, I can see how that is perhaps an effective way of going about things. Whether it'll work or not, that's to be seen. But one thing is for sure. In this first salvo of questions from the court, we get a taste of what they are looking for. Whether the petitioner will satisfy these things, time will tell.
Absolutely. Well, we'll wait to hear from the side of the petitioner, who will be addressing the press as well. We'll take you there when they get ready. But our election petition update is brought to you in association with Petrosol. Clean fuel in full quantity is always a delightful experience. Also, DBS Roofing. We truly are your roof experts. COA Mixture, the immune booster for your general well-being. So after several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experience the amazing touch of Colorlink Plus roofing sheets in 26 years, which means Colorlink Plus roofing sheets always stay clean and beautiful for you. And there's more. They're giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited in Accra on the Spintex Road in the DBS building near Papaya. You can call their hotlines 024-8084-4444. That's 024-084-4444 or 054-3286 637, or visit the other factories in Kumasi, Tamale, and Takrady. DBS Industries Limited. We truly are your roof experts. Now, due to hard times, we have become value hunters, but are we hunting for value the right way? Remember, your engine is more valuable than just cheap fuel. Be smart, hunt for holistic value. Holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, we serve clean fuel in full quantity at a fair price, and that is holistic value. So come to us, Petrosol, clean fuel in full quantity. So finally, Kojo, General Mosquito, Asiedu Nketia is done with the cross-examination.
Yeah.
How has it been? I mean, it's been more than a day because he started on Friday, ending today.
I suspect that following the pedantic, painstaking, grueling cross-examination of lawyer Akuto Ampao today, General Mosquito, as he identified himself to the judges in that light moment at the end, he's going to be quite relieved to be able to stretch his legs, get himself a drink of water or whatever it is that he'll need to calm himself at this point, because that was intense. That was intense. I mean, especially compared to, Friday's cross-examination, which he seemed to be very relaxed during. He seemed to be more in control of that than today's, where Mr. Ampao insisted on wresting control from him at every
We're going to go back to the court now. Marietta Brew, Apia Opong speaking.
He has said undermines our case. Indeed, everything he said goes to points to the fact that we are entitled to the declarations that we are seeking. But several interesting things stood out today. Let me start with the video. The video that they sought to show to try and dent the credibility of the General Secretary didn't happen as they thought it would. In the end, his credibility rather soared. If you watch the video, and I'm sure you all watched it, it is clear from the video that he never said at any point in time that the petitioner had won the elections. In fact, what he did were projections, and rightly so. He stated that based on the 141 parliamentary seats that we had won, the projection was that we would win the presidential slot as well. Those were projections he made. And so they were unable to show from the video that the general said what it is they were trying to prove. So of course they flopped in that regard. The other thing that came out clearly was that there were ever-changing figures from the general's testimony. Now, from their own cross-examination, they described these ever-changing figures as manifestly erroneous. We had the 9th December figures of 13,434,574, 10th December 13,119,460. Then in their paragraph 24 of their answer, that's the first respondent's answer, she talks about 13,121,111. Yet again, today, there were corrections made. And we saw that from the cross-examination on Techiman South. On the face of that, their own exhibit, it showed 97,227. But when they did the tally or the collation, it was 99,436. So when we make the point that based on their own declarations, that's the EC's own declarations, there are errors, we are right. And it has been proven by the cross-examination that they conducted that we do not know what the figures are. Based on her own declaration, nobody got more than 50%. And the declaration I'm talking about is the 9th of December declaration. Also important is the issue of padding. They cross-examined the general on the issue of padding. And you can sense from the cross-examination that they admit that there was padding. What they tried to portray was that on a pen drive, there was an indication that there was also padding in favor of the NDC. Now, if they admit that there was padding, then obviously we are dealing with a very flawed election. That is the point, and they admit it. It's a clear admission of a flawed election. And he also made the point that what we attached in terms of padding were only samples. Only samples. So you can't take a sample and deduct it from a whole or an absolute number and get any results, because that sample is simply what it is, a sample. In the end, there were also questions from the bench about our own figures, but I think we need to make it clear, and it's been made clear over and over again. We are here challenging the EC on its own figures. Its own figures. What are those figures? There's the 9th of December, there's the 10th of December so-called correction, and there's also the figure in their paragraph 24. And then today we realize that even in some of the constituencies, and they themselves brought out the example, Techiman South, there are errors. So if you ask us, what are our own figures? How are we going to get our own figures based on all these flawed sheets and different figures? And so we stand by what we are saying, that based on her own declaration, nobody got more than 50%. So today we are happy with the cross-examination of the general. We are happy with the results, and we think that our case was made clearly in the court today. So if there are any questions.
Yes. Sisters.
Yes, the interest in the alternative figures, as the petitioner would have or should have brought to court, maybe it's not a matter of interest to only the bench. A lot of us journalists followed the election keenly, and we know that on all sides, the NPP, the NDC, the CPP, each political party had, call it a collation center or a tabulation center, whatever the name was. But each political party was able to, following the reports from their representatives at the polling stations, tabulate the figures, and at the end was able to tell whether or not they were leading, they were behind, whatever the case may have been. Is it the case that based on the tabulation that the NDC did of the election results, it is not possible for the petitioner to tell us some figures which probably directly contradict the figures that the EC chairperson announced on the 9th of December?
I mean, that's a good question, but having regard to the case we have even brought to the court, I don't even think it's necessary. They themselves have different contradicting figures. Why do you need another one from us? They are different contradicting figures. And that is the point we are making, that the EC themselves, what are the figures?
Yeah, any other? Akabile?
On the point about the alleged vote padding, I just wanted to find out, because we heard General saying sample. I mean, what is the full range of this vote padding that the petitioners team detected? And if indeed you detected that full range, should you rather not be making the case that those votes be annulled? And the other one relates to General's point about the first time he's seen the contents of a pen drive. If you could clarify that point for us as well.
Okay, I think let me start with the issue of the pen drive. The information on the pen drive was printed for the general. It was printed for him, so he saw the hard copy. He didn't actually see the pen drive, you know. And from what I could see on the screen, they were actually reading from the names of the folders, which he would not have. He would have the printed document, because of interest to him was the information on in the documents and not the names of the folders. So that is how it is explained away. It's not to say he didn't know what was in the folders, but what they read was based on the names of the folders. I hope that is clear to you. Then the other question was what?
The vote pattern here.
Why did you bring
more?
That's not a case in court.
That's not fundamental to that.
Because you kept saying sample, and the sample came to 4,000 in terms of general's witness statement and about 5,000 in terms of the petitioner's statement. The full range that you discovered in your analysis, how many votes are we looking at, and why are you not making a request with evidence to have those votes annulled instead of relying on the declaration of December 9?
Well, that is the choice that we made, that we will challenge the declaration of December 9th. That is the choice that we made. We brought samples to show how flawed the election was, but our choice was to challenge the very declaration of December 9th.
Okay, we can do the P now.
Yep.
Is that okay?
Okay. Okay. Yo, abusian for yebeda mwasibiem se masanso ajebrese.
So both sides are happy. Kojo, we've heard from Marietta there, and they both have won.
Yes, well, I mean, they can't both be right. But it's fascinating to see the perspective that Marietta advances on behalf of the petitioner. Okay, so she thinks that the videos that were shown in court actually went to confirm the witness's credibility. Now, I can see where she's making that conclusion from, because the main thing that the witness was accused of was of making a declaration that their candidate won, that the petitioner won, and then coming to court and claiming that nobody won. That is what Mr. Ampao had sought to, if you like, discredit with the videos. And watching the videos from beginning to end, there was no instance where Mr. Asiedu Nketia himself declared that this person won. There was a part that Mr. Ampao sought to translate to mean that. The petitioner insisted that that's not what he meant and that he was just making a projection. But it's fascinating because there were some very clear statements that the petitioner has won, made by others, like the deputy. I believe his deputy...
Peter Otukno?
Mr. Peter Otukno. And the question then comes, as General Mosquito himself says, he's the CEO of the party. So the question will have to be considered by the court. Does the CEO take responsibility for the statements made by other officers? I mean, if a deputy minister makes a statement and the minister doesn't correct it, can he later in court distance himself from that statement? And then finally, the NPP... the second respondent referred to the pen drive in court. Marietta says this means the second petitioner is admitting that there was padding. The general said that the information they've provided, the evidence they provided is just a sample. So the question is, will the court rule on just a sample and determine that there was more or not? I mean, if you bring evidence that Mama V killed 2 people, will I then decide that it means that the 8 other dead people were also killed by Mamavi? We'll see how the Supreme Court deals with these things.
Absolutely. Well, thanks for using our hashtag election petition. We're grateful to Petrosol, DBS Roofing and Coa Mixture for bringing us the election update. Join us tomorrow at 9:30 when the court sits as it continues with its cross-examination. I am Mama Vio Uswabuaje, been here with Kojo Yankson. Gifty and Apia comes up with Pulse. But first, here are excerpts of Mr. Asiedu Nketia's testimony today.
The thrust of all these statements in the various clips is that President Mahama had won the 2020 presidential election.
My Lord, these statements, according to the videos, were made at different times.
I didn't ask you when they were made.
Some of them were made after declaration, some before declaration, and so on. So it is difficult to put all such together and say that at this point, this was what was said.
No, I'm putting it to you that these statements were made before declaration.
My Lord, my viewing of the video indicates that some of the statements were made after declaration.
Even better. And so you admit that some of the statements saying that the petitioner had won the elections were made after the declaration, not so?
From what I have watched here with everybody here, I can see that this is not a video of one event. These are videos picked and pieced together, and some of them relate to a time period before declaration and others relate to a time period after declaration.
Now, it is no secret that interspersed between these press conferences, the NDC, under your direction, had organized several demonstrations in Accra, stating that the petitioner had won the election and warning the first respondent not to subvert the will of the people.
My Lord, the NDC had organized several demonstrations with three main objectives. One,
please, I've not asked you
the killing of innocent voters at polling stations by security officers, and nothing seemed to be happening. The NDC made that was one of the purposes of the press conference. The other purpose of the press conference.
Please, I have not asked you the purpose, so answer my question. Please, and don't be taking.
Can you restate?
Don't be taking instructions from, lawyers on this side, please.
Please, let's observe. Please, Deacon, please.
My Lord, I know what I'm talking about.
We are closer to them than you. We've not witnessed anything. Please.
Yes, please answer my question, and you had your opportunity to write your witness statement. So now you answer the questions. You understand?
Please, I'm asking the question again, and I answer according to my ability and what I consider to be the answer to the question.
I'm saying that interspersed between these press conferences,
yes,
the NDC organized a series of demonstrations, the object of which was to...
Tin is loaded. You see, it is double-barreled. Can't you break them?
Organize a number of demonstrations. Is that so?
Yes, we did.
And one of the clear objectives of these demonstrations was that the petitioner had won the elections and the EC should not subvert the will of the people.
My Lord, the objective that relates to the presidential elections was that the results as declared were flawed. And the commission itself has accepted that the results were flawed, and that's why they kept changing the figures.
So you admit that you said that the results were flawed?
Yes.
Who, in your view, won the results? The elections?
My Lord,
who?
We are not interested in winning or losing a flawed election.
Very well.
We want the election, we want to be winners of an election that is credible.
Now, it is also true that notwithstanding all these statements that your party, yourself, and the petitioner had made, that the petitioner had won the election, when you eventually filed your petition, there was nothing in the petition about the petition having won the election.
My Lord, I have indicated earlier.
No, please answer my question.
Please, I'm about to answer the question, unless you are not ready to listen to the answer.
I've asked you that when you filed the petition.
Yes, my Lord.
Yes. There was nothing in it to the effect that the petitioner had won the election.
Hello there, we're live from our studios here in Kokomlemle on digital address GA0992539. Our lead stories this hour. Almost 6 hours of petitioners witness in the Boxers lead counsel for President Akufo-Addo grilled him